We're going to start a little early and maybe do things slightly out of order because some people have schedules and trains, and so we will start with this panel, and then when Commissioner Phillips comes, maybe after the first presentation, we'll interrupt the panel for Commissioner Phillips and then go on with it. So I think it's safe to say that there is more debate about antitrust policy these days than there has been for a considerable amount of time. And critics of the current, and it's motivated largely by the emergence of large tech platforms. And critics of the current approach, at a minimum, suggest that antitrust policy has been too lax and it should be more aggressive, but many of them go further than that and suggest everything ranging from common carrier type regulation to a fundamental reevaluation of our approach to antitrust, including breaking up some of the large tech platforms. In this conference, we're going to feature 6 papers that address issues related to antitrust and the platform economy. And these papers, along with a 7th one that by Catherine Tucker, who unfortunately couldn't be here today, are going to be published in a special issue of the Review of Industrial Organization. Thanks to Larry White, the editor, and that will be out probably early next year. But the papers will be available on the website as they get finalized. This first panel is titled "Lessons from History," and antitrust critics frequently point to the purported successes of landmark antitrust enforcement actions, mostly Sherman Act Section 2 cases. And the 2 papers that we're going to hear today by Bob Crandall and John Nuchterlein and Tim Uris are going to examine in some detail what lessons can be drawn from these actions. You have the biographies of the participants. Bob is an adjunct senior fellow at TPI, and for a long time was a senior fellow in the economic studies program at Brookings, and he will speak first.
Today I'm just going to talk for a short time about the setting for all the talk today about dealing with the internet giants, FANG, or whatever you want to call them, Facebook, Apple, Netflix, Google, etc. Most of the literature, the popular literature you see advocating antitrust for this area usually cites 2 phenomena. One, how well antitrust worked in the early 20th century to break up the trusts, the evil trusts of Rockefeller and American Tobacco, etc., and railroads. And secondly, how bad the Microsoft decree was and how we could have gotten a much better decree which would have increased competition much more rapidly. I think both invocations, as I say here, are somewhat mistaken. Now, if you look at the structural remedies under Section 2, and this is based on an article I did a number of years ago published in the Oregon Law Review, which, by the way, it was to be presented as testimony in the Microsoft remedy case, but of course Judge Jackson decided he didn't need any testimony, he didn't need a hearing, he could just let the government have its way, a finding which ultimately led, in addition to other things, led to his removal from the case. But going back to some of the earlier Section 2 cases where there were structural, or at least structural remedies are recommended, Standard Oil, 1911, probably wasn't needed at all. The dissolution was poorly designed because it gave every stockholder a proportionate share in the spun-off companies. But already new discoveries of oil around the country, particularly in the Gulf region and out west, had created a lot of competition, started bringing the price of oil down. And there's little evidence that the decree itself reduced the price of oil. American Tobacco essentially converted a trust, the American Tobacco Trust, into a 3-firm oligopoly. I did a little empirical analysis of that. No evidence that breaking them up from 1 to 3 had any effect on cigarette prices. Alcoa, there was no divestiture of Alcoa assets, but there was a structural relief in the form of selling the government's World War II plants to compete with Alcoa to Reynolds and Kaiser. Again, very little statistical effect on real aluminum prices post-1945. 1948, Paramount is an interesting case because here you had 5 major distributors who owned theaters, 3 minor distributors who did not. Initially, the court ruled for some sort of competitive bidding between the theaters and the distributors, but the Supreme Court asked them to reconsider, so structural relief was finally ordered in 1948, and the companies were either induced to or required to divest their theaters, the distributors were, and all did so fairly promptly, just as television was destroying the value of the theaters. So essentially Antitrust rescued them from themselves. The only one who delayed, in a very costly delay, was Howard Hughes with RKO. Several other important cases afterwards, United Shoe Machinery and so forth, but the one which is often cited as a successful example of Section 2 in structural relief is AT&T, being forced to divest their operating companies in 1984. But what is often not discussed is what the long, tortuous path, regulatory path after the divestiture. The idea of having a clean divestiture, a clean structural solution with the courts getting out of the way is a little naive. In the Paramount case, the Antitrust Division was involved in licensing agreements between producers and distributors of films and theaters for decades afterwards. And in the case of AT&T, the court got horribly backed up with trying to enforce a decree in a rapidly changing, technologically changing market. And as a result, the Congress acted in 1996, passing the Telecom Act, essentially relieving the court of having to enforce the decree and trying to promote wireline competition through network unbundling. That went on for another 9-10 years, inducing large numbers of companies to come in and try to use the incumbent networks to provide local competition, spending considerable money on capital, which essentially was wasted. So the cost of the decree might have exceeded the value of the rate rebalancing and the increased competition in long distance, so we don't know, and I've never done a careful analysis. But let me say, even here, we can't be sure. What we do know is that competition eventually came to telecom. It came because of wireless and because of cable competition. And we can't know, we don't have the counterfactual of what would the regulatory environment have been like had there been no AT&T case. The regulatory environment was very, very pro-competitive after the AT&T case, and as a result, wireless thrived with spectrum auctions, and cable was allowed in and competed without much regulation in the telecom area. But what we know from all of these cases is that the government had difficulty anticipating or even realizing the competitive situation by the time they structured the decrees. Let's get to U.S. versus Microsoft. We know this case was won by the government. DOJ sought structural relief. Judge Jackson decided that they should get it without a hearing. He was reversed by the Circuit Court of Appeals for D.C. And the final decree, which was negotiated under the next judge, was essentially a conduct remedy, which just 2 days ago I heard the current AAG, Mr. Delarim, comment on, saying he doesn't like conduct remedies, he really likes structural remedies. Seven years later, Carl Shapiro writes an article published in '09 saying that the decree was far too easy on Microsoft. It should have been a stricter decree to increase competition more rapidly. Competition hadn't grown, and we made a mistake. The courts made a mistake by not requiring structural competition. The problem is that the vertical divestiture the government wanted was not, according to the Court of Appeals, was not justified by the liability findings in the case at large, because they dropped the notion that it was the application's barrier to entry that was the principal problem, but rather it was the access to middleware, the browsers and so forth. Well, after Shapiro's article, I don't know if you can see this, it's awfully small. The markets became quite competitive, particularly the operating system market. Not in the desktop market, not in the market which was principally under litigation with US versus Microsoft, but because of the introduction of new devices, new technology, namely tablets and mobile phones, smartphones. And as a result of that, Microsoft's share of all device operating systems fell by March 2018, the numbers I have here, to 36.6%. Sure, they still had 82% of the desktop market, but the desktop market was being competed with by tablets and smartphones. Also, in the case of internet browsers, which was at the center of the middleware controversy in the Microsoft case, when Carl Shapiro was writing, Google had not introduced Chrome. They obviously had a large part of the search market, and finally were induced by some new employees to get into the browser business, though they didn't really want to take on Microsoft head-on in the desktop area. But eventually, Chrome introduced about late 2008. Eventually, Chrome came to dominate the browser market, driving, as you can see here, the blue line, or whatever color that looks like on the screen, up to somewhere in the high 60% range, and Internet Explorer and Edge way down in the 10% range. So competition did break out after Microsoft, but it broke out because of new technology, new devices, not necessarily because of the decree. Now, some people would argue that the decree did have an effect by limiting Microsoft's animal spirits, and they wouldn't compete as aggressively with Google because of this, because of their conviction in the Section 2 case in 2000. But that's obviously speculation. Well, now, can we use Section 2 to attack the dominant internet giants? Well, first of all, I guess we're going to get into this with David Evans a little bit later about how you measure market power and two-sided platforms. But is digital advertising an antitrust market? Do Facebook and Google dominate that? Well, they account for less than 60% of national digital advertising, including other types of advertising are probably in that market too, unless someone can show that digital advertising is an antitrust market. And Amazon, when the last numbers I saw was only 3%, though I think they're growing now. Amazon itself has less than 50% of total online retail sales, and they're being competed with by, particularly Walmart announcing yesterday, seems to be doing relatively well. But either set of numbers hardly suggests a level of concentration which would be necessary by itself to bring a Section 2 case. Now, is search an antitrust market? Again, I'll leave it to David Evans to talk about this. But if it is, then Google might have a problem because it's got 93% of the worldwide internet search business. I don't know if it's a market. But if so, did Google monopolize? I mean, first of all, the first step in a Section 2 case is to determine monopoly power. Second, to determine if it was obtained through some method which is anti-competitive and therefore needs some sort of relief. I don't know that that's how, I don't know enough about how Google got to its current position in search, but it's not clear to me that anyone has suggested a convincing argument for monopolization and for violation of Section 2. Facebook accounts for less than 40% of social media visits. Twitter lags far behind at 7%. Those would hardly seem to be enough concentration to worry about. Now, there are other reasons perhaps that people are talking about regulating these internet giants, but they have to do with privacy and other issues, not using Section 2 of the Sherman Act. And what I would suggest is that it's going to be difficult, though we'll listen to David a little bit later, to bring a Section 2 case against them at this point. The most daunting problem, obviously, even if you win in Section 2, and there's a number of us were talking about this when Microsoft was brought, is what's the relief? If structural relief hasn't worked, that well in the past because of rapidly changing markets. Think of how rapidly changing this market is. As I mentioned, critics of the Microsoft decree, including the current AAG, find behavioral remedies unsatisfactory. By the way, I'm not saying that he's a critic of the decree, but he is a strong proponent of structural remedies, not behavioral remedies. And as I said earlier, it's difficult to see how the Microsoft decree was responsible for unleashing the competition that developed from Google, Apple, and others. Anyway, any case that is brought under Section 2 has to tie whatever the anti-competitive conduct was to the remedy. The ones that are bandied about, whether they could be tied to any anti-competitive behavior, would be to require a spin-off of YouTube by Google, or spin-off of Instagram or WhatsApp by Facebook. I'm not suggesting that these would solve any problems, or that they would even be feasible, even if a Section 2 antitrust case was brought. Well, finally, in conclusion, what I'm suggesting is that markets change rapidly, and often competitive entry solves the problem, competitive development solves the problem that Section 2 cases identify. And certainly in the current technological environment that the internet giants find themselves in, we would expect this to happen even more rapidly than it did for, say, Standard Oil in 1906 or thereafter. The Microsoft decree, I think, probably had at best a limited role in inducing competition. And finally, I don't know how we can know if a potential structural remedy in Section 2 case against Facebook, Google, or any other of the internet giants would be more effective than relying on future, currently unanticipated, at least by me, changes in the digital marketplace. Thank you.
We're going to take a quick break now so that we can hear from the Honorable FTC Commissioner Noah Phillips, who, he with the Federal Trade Commission, and before coming to the FTC, he was Chief Counsel to U.S. Senator John Cornyn, Texas, on the Senate Judiciary Committee, where he advised on legal and policy matters, including antitrust, constitutional law, consumer privacy, fraud, and intellectual property. And I will leave it there, and we'll hear from him. Thank you.
Thank you for the introduction, Scott, and thanks to TPI for hosting this excellent event, and for everyone for joining us. I'm a great believer in the power of technology, but this morning is a good reminder that there are other forces in the world that can best even our best technology. So for those of you brave enough, smart enough, quick enough to make it here, I salute you. And my apologies for any inconvenience that my lateness may have caused. I want to begin with a quick caveat. The remarks I make today are my own and not those of the Commission or any of my fellow commissioners. The 40th anniversary of the antitrust paradox coincides with a renewed nationwide interest in U.S. antitrust law and policy, occasioned in no small part by the rise of the platform economy, in the title of today's event. As we consider the questions of today, we must understand the lessons of yesterday. That is, the historical and economic facts and circumstances that animated the robust debate over antitrust some 40 years ago. Those who propose to change antitrust must answer not only how their solutions would address the ills they perceive, but also how they would avoid past mistakes. Robert Bork published The Antitrust Paradox at a time of economic malaise, widespread concern over faltering U.S. competitiveness, and internal doctrinal inconsistencies plaguing antitrust law, and with that, U.S. merger strategy. American firms were bloated and inefficient, hurting consumers and workers alike, while foreign firms, often bolstered by the domestic industrial policies of their home countries, were competing aggressively. American corporations needed new management, new governance, and new antitrust. The crux of the criticism 40 years ago was that while purporting to promote the competition America so desperately needed, antitrust law had developed in such a way that it actually condemned the very efficiency, innovation, and other competition it purported to protect. Courts condemned mergers among competitors with very small market shares, some with under 3%, of relevant markets that would have allowed lower prices for consumers. They condemned as unlawful monopolies, firms that were admittedly offering better prices and quality to consumers. So, following decades of rigorous debate among Nobel laureates, economists, jurists, scholars, and other experts across the political spectrum, including Robert Bork, antitrust law acknowledged these internal inconsistencies, and it responded to them. It embraced a consumer welfare standard, which, tethered to current economic learning, provided a clarity and cohesion that was previously absent. And it permitted transactions that would help consumers. For 40 years, in the main, that was the consensus. Today, critics are challenging that consensus. And their challenges go to the heart of where antitrust law should aim and what it must do to achieve that ambition. Much has been said and will continue to be said about the theory, economics, and the politics of these critiques. Elsewhere, I've expressed my skepticism that many of the economic phenomena attributed to the consumer welfare standard are properly linked to antitrust law and policy. As much as antitrust experts may not like to hear it, there is more, a great deal more, to economic policy and to the development of American businesses over time than antitrust. The antitrust laws, of course, are powerful tools when properly targeted, but they are not and never have been a panacea. I want to leave aside for today the debate about what antitrust should aim to do or whether we need new antitrust laws. Instead, I want to focus on some of the ideas about how a new antitrust regime might function. Much of the rhetoric and punditry regarding the supposed failings of modern antitrust is taking place without due regard for how a different regime would actually look. Often pithy op-eds without adequate recognition of history, economics, or antitrust law, bemoaning the state of an industry or of the working class or of democracy and so on. This is a real debate with real consequences. We've gotten it wrong in the past, and the national interest has suffered as a result. This debate deserves treatment in depth. That doesn't mean we shouldn't have the debate, but it's on critics to propose a better way, and on those defending the status quo to engage with those proposals. To their credit, some of the antitrust critics have made proposals, some of them. And that is some of what I want to discuss today. One proposal, which some have taken to calling neo-structuralism, is in many ways a return to the antitrust paradigm that preceded the economically grounded consumer welfare standard. The structure, conduct, performance, or SCP paradigm, for instance, theorized that concentration correlated to competitive measurements like price and margin, and undergirded a consensus that concentration alone was to be prevented. Courts and enforcers based decisions on the era's leading economics, as expressed in cases like Philadelphia National Bank and guidance like the 1968 merger guidelines. The earlier regime was generally characterized largely by a big is bad mentality. And much of that was based on intuitions, much like some of those being expressed today, that if firms were permitted to grow too large, average Americans would suffer harms to their dignity, to their independence, or other socio-political values. Neo-structuralism finds expression today in such proposals as banning outright or presumptively condemning transactions over a certain size or of a certain structure. Such laws would offer enforcers and merger lawyers simple rules, but would they be good ones? The rationale for bringing structuralism back focuses on consolidation that has since occurred, a result, the theory goes, of lax antitrust enforcement caused by the consumer welfare standard, and that should be avoided for economic, social, or other political reasons. What this nostalgia reflects, I fear, is a thorough consideration of why such a consensus emerged decades ago to bring antitrust to where it is today. First, there was little dispute that many pro-competitive transactions, that is, deals that would help shareholders, employees, and customers alike, were barred. We know today that size and even concentration may, and often do, result from efficiency and healthy competition as firms achieve economies of scale or reinvent offerings to consumers. Real people, especially the less fortunate, benefit from competition, getting goods and services for less. We want US firms to be competitive, especially in the face of global commerce. And I fear that US competitiveness, often expressed in scaled firms or innovative and creative destruction, is now being offered up as a sacrifice in return for the regime described by Supreme Court Justice Stewart in Vaughn's Grocery as one in which the government always wins. The trouble was, most others, notably American consumers, lost. Second, the result wasn't reduced corporate power or better competition among firms on every level of the supply chain. It wasn't clearly fewer mergers or less consolidation, but worse mergers and consolidation. Disfavoring both horizontal and vertical mergers left firms to turn to conglomeration for growth, and that was bad for everyone. Skewing market incentives should be expected to yield the unexpected, and often bad results. Third, modern economics do not support the wholesale bans that some neo-structuralists have proposed. While the SCP paradigm was not the only basis for the previous model, it was the leading economic basis, and it was largely debunked. Modern economics demonstrates that many mergers, the vast majority of both horizontal and vertical mergers, are not harmful to competition or consumers. So while concentration has a role in modern antitrust enforcement, and it still does, it is far more nuanced. Which brings me to one of the most concerning new ideas for antitrust, and that is the rejection of economics itself. As a threshold matter, calls to reject antitrust connection to economics often mischaracterize two things about the consumer welfare standard. First, it does not focus only on short-term price effects. Price and output effects are often more observable and measurable, and since no plaintiff, not even the FTC, is omniscient, short-term effects are often emphasized. The further into the future we are trying to predict, the less certainty we can have. I think several of us are still disappointed that it is now 2018 and we still do not have the flying cars that Back to the Future 2 promised us. But while near-term price and output effects are an appropriate focus in reviewing mergers and conduct, they are by no means the sole focus. The antitrust agencies routinely consider effects on additional metrics that are critical to consumers, including quality and innovation, in both the short and the long term. The consumer welfare standard not only allows, but requires this analysis. Second myth, the consumer welfare standard is not merely the concoction of a few ideologues at the University of Chicago. While scholars at the Chicago School and of the Chicago School, from Aaron Director and Ed Levy through to Richard Posner and Frank Easterbrook and yes, Robert Bork, played an impressive role in helping to develop antitrust economics, they were among many. In the last several decades, economists of many schools, including several of whom, if you call them Chicagoan, they get offended, have contributed critically to developing our understanding of antitrust economics. Mischaracterizations aside, moving antitrust law away from economics would erode coherence and predictability, critical features of any legal regime. Not only did the pre-consumer welfare regime prevent efficient transactions, it did so inconsistently, blocking deals that would help consumers, chilling the market for corporate control, and preventing effective business planning. Economics provides a common language for analyzing competitive behaviors. Plaintiffs and defendants can argue as to the magnitude or the likelihood of various effects, but everyone knows what the ground rules are. And at the end of the day, everyone knows how the winner will be decided. This clear rule of decision provides strong protection against agency capture, as courts and the public can observe when an agency action does or does not align with the law. It is also essential to global commerce, as antitrust regimes proliferate internationally, including in countries where the rule of law is not as strong. Another common proposal to reform antitrust has been to supplement or replace the consumer welfare standard with a multi-pronged standard that incorporates various socio-political goals. So advocates have proffered various additional factors, including the effects on employee incomes, or wages, new business creation, inequality, political power. The Roosevelt Institute's effective competition standard, for instance, instructs, quote, agencies and courts to use the preservation of competitive market structures that protect individuals, purchasers, consumers, and producers, preserve opportunities for competitors, promote individual autonomy and well-being, and disperse private power. Ambitions like these for antitrust remind me of Donald Turner's 1965 quip about merger defenses. That's my quote. In the brief time that I have been the head of the Antitrust Division, I have had proponents defend a contemplated merger on the grounds that it would promote the national defense, assist in solving the balance of payments problem, reduce unemployment, and contribute to the administration's anti-poverty program. I fully expect to hear before long that a merger should be allowed because it will contribute to the president's program for making America beautiful. Whatever the factors, a multi-factor approach, in particular one that contemplates amorphous goals, presents several real risks. First, it takes time and effort fully to flesh out the boundaries of any new standard, and more so where complex factors are at play. The courts and antitrust agencies have spent decades developing the consumer welfare standard, which is comparatively well established and well understood today. Any new multifaceted standard would introduce significant uncertainty into antitrust enforcement, encouraging, among other things, rent seeking by corporations eager to exploit unclear standards, say by touting their contribution to the national defense. A new rule that proposes to balance several potentially competing interests provides an excellent opportunity for just such exploitation. Second, consider the proverb that he who serves two masters serves none. In considering antitrust questions, how are we, businesses, lawyers, and enforcers like me, to trade off competing interests? Consider, for instance, a merger that would allow a combined firm to increase worker wages significantly, raise prices to purchasers, take political power from a larger competitor, and hamper new business creation. Okay, these are all factors under consideration. Assuming we could even reliably identify all these effects, which itself is a sizable task, how would an enforcer trade off those competing values? What's the common metric, and how would a court provide a meaningful check on such an amorphous decision? Third, trading off consumer welfare against competing interests necessarily decreases consumer welfare. Embracing a multi-pronged approach would signal that we are willing to accept some amount of harm to consumers, including necessarily higher prices, lower quality, and less innovation in exchange for other values. Maybe it's an insurance company that charges more because now doctor groups can collude to charge more to the insurance company and increase the cost of care. That's a small group of workers against a big, powerful corporation right there. Court decisions before the economically grounded consumer welfare standard did indeed protect the smaller and efficient competitors, but they did so at the expense of average Americans who were less able to afford, for instance, groceries. And groceries are very important. Allowing harm to consumer welfare most significantly impacts the less well-off, with the least purchasing power, who are in less of a position to absorb an increase in price or other harms. Forgive the biases of a consumer protection enforcer, but we should keep the consumer top of mind. Finally, many of the socio-political goals being considered as potential candidates for inclusion within antitrust analysis are key issues facing our society today. I worry about inviting courts and enforcers to imbue decisions with their views of these very goals. Beyond the issues themselves, a lack of clarity invites decision makers, judges, agencies, enforcers like me, to substitute our preferences for the law. Among other things, that injects politics into the equation, which no one should want. Should it matter whether I believe that a firm has too much political power, or maybe not enough? I worked on Capitol Hill for 7 years, and I witnessed industries vie over legislative fights. So if I see tech losing a legislative fight, and they do a lot, does that mean we should favor their mergers? That would be absurd. How we structure politics, how we distribute the gains of growth, what level of bargaining protection the law should offer labor vis-a-vis capital, these are real questions, important questions. But I very much doubt that antitrust can solve them, even if it sought to do so. Because these are such important questions, they deserve resolution through the democratic process. they should be given the political attention that they deserve. As there were 40 years ago, when the Antitrust Paradox was first published, there are important discussions today regarding the appropriate goals of antitrust law and how enforcers can best achieve them. I have focused my remarks today on some of the proposals and some of the concerns that I have with them. Acting deliberately and with solid foundation for changes is critical to any successful antitrust regime. Antitrust enforcers like me still have much to learn, and we are actively continuing our educational efforts and adapting our enforcement priorities and efforts as appropriate. I invite all of you to join me in that effort. Thank you. Sure. Any questions?
Yeah, small audience today.
Hi, Drew Clark. It's on.
I mean, I can hear you.
There we go. Well, it's on. Okay, there we go. Drew Clark with Broadband Breakfast. Could you talk a little bit about I don't know how we would characterize it, what goes in the antitrust bucket and what goes in the legislative policy bucket? So, for example, you referred to privacy as an issue that is in some ways stirring or maybe motivating a lot of the criticisms of Google, Facebook, or things like, you know, vulnerability to election manipulation or fake news, et cetera, et cetera. So how does one, you know, tee out the issues that are non-related to antitrust and those that would be subject for proper legislation? Or maybe to put it another way, how do you keep all this stuff out of antitrust, and should you keep all this stuff out of antitrust?
So Drew, thanks for your question. Thanks also for paying close attention. I didn't actually mention privacy today, but I have in the past, which means you're paying attention, and I really do appreciate that. Look, I think the law today is fairly clear about what counts and how it counts. There are a lot of really interesting questions that antitrust scholars and law enforcers and courts continue to struggle with, and that they're going to continue to struggle with, because the law isn't completely simple. My point is that other values, first of all, don't fit naturally into our framework, and second, put us in a difficult position where we may not be able to make clear decisions, and perhaps more importantly, businesses may not be able to plan around it. With respect to privacy specifically, number one, we have a federal privacy regime, which I've described in other speech. Number two, we're having a very robust debate right now nationally whether we ought to change our privacy laws. That's an important discussion, including about asking, you know, what are the harms we're trying to solve and what are the most efficient and effective ways to solve those harms. But that doesn't necessarily fit into an antitrust bucket as you described it. One thing I have said publicly and will continue to say publicly is that as we consider a different privacy regime, we ought to keep competition top of mind. We ought to remember sort of long-standing rules that where you impose regulations, those are costs of compliance. And larger firms may be better able to bear it than smaller firms. Additionally, there are certain firms, let's call them incumbent firms, that have a lot of data. Keeping other firms from getting access to those data may entrench those firms further. That doesn't mean, by the way, that we don't necessarily need to move forward on privacy legislation, but it does mean we need to keep competition top of mind.
So are you seeing any real effects of this debate? I mean, we don't see it in the very largest types of mergers, but you see or will see hundreds of them coming across your desk. Do you see any changes in behaviors in how firms are, any change in how firms are now behaving with respect to mergers because they're worried about possible changes, or is this still just a completely academic discussion?
I wouldn't call the discussion completely academic. It's a very robust and broad debate. It includes a lot of policymakers and so forth. I don't know enough to answer that question. I don't know that I have a view that firms are changing behavior. There are certain, let's call them current topics in antitrust law that are more enthusiastically being looked at by European enforcers. So the common ownership phenomenon on which I've spoken, privacy, are things that they're apparently doing inquiry in Europe about. And the FTC has addressed questions, at least with respect to privacy in prior enforcement, rejecting that as a principled basis to sort of block a merger. But I don't know, whether there's a change in firm behavior. One of the points I made, Scott, is that a lot of what drives business behavior, and always did historically, is not simply antitrust, right? There are a lot of other, even with respect to mergers, there are a lot of other considerations that firms make. Okay, well, thank you.
Our next speaker is John Nuchterlein, who's written a paper with Tim Uris. Very interesting paper. John is a partner at Sidley Austin, former general counsel at the FTC, among other things.
I am John Nuchterlein. Tim Uris isn't able to be here this morning, but he will be here for lunch. I am going to give a concrete illustration of all the ills just described by Commissioner Phillips. I'm gratified to see that this is a widespread concern at the FTC right now. Bruce Hoffman also is reminding us to remember the mistakes of the past so that we don't repeat them, amid calls to repeat them over and over again, particularly in the high-tech industry. I'm going to look, though, at a very low-tech industry. This is the grocery store industry of the mid-20th century. It involves a case called A&P. By way of personal disclosure, I was a bag boy at the A&P in the 1980s. I will not let that influence my view of the government's persecution of that company. But for those of you who are too young to remember it, A&P was a huge commercial presence in ordinary Americans' lives. Mark Levinson, who is the nation's leading biographer of this benighted 20th century company, sums up the astounding commercial success of A&P. Even by 1929, it became the first retailer to sell $1 billion in merchandise per year. It owned 16,000 grocery stores, 70 factories, and vertically integrated, and more than 100 warehouses. This is in an age when most people bought their groceries from very small neighborhood grocery stores. A&P was a huge disruptive influence on American grocery retail. So how did A&P succeed so extravagantly by the mid-20th century? There were really four factors. One was disintermediation. In the old days, grocery production and distribution was a highly segmented business with wholesalers in the middle taking profits that ultimately led to higher prices for retail goods. A&P went right around the wholesalers, and it bought in gross, not just from its own manufacturing facilities, but from other third-party producers as well. A&P also achieved economies of scale that were not even remotely rivaled in the grocery business by the time A&P arrived on the scene in the 20th century. Vertical integration, A&P kept costs low by vertically integrating not only into distribution but also into food production, and as we'll see, A&P also had a vertically integrated purchasing agent that went around the country and bought produce at very low rates from farmers. And finally, A&P was one of the great innovators of the 20th century. We don't commonly associate grocery retailing with innovation, but A&P was an outstanding innovator. Among other things, it foreshadowed the successes of 21st century tech giants by using data to inform its purchasing and inventory decisions. So who benefited from A&P's success? Well, that's pretty straightforward. It was ordinary consumers who paid less for groceries and had a wider selection of groceries at their local A&P store than they could achieve through mom and pop grocery stores. Who didn't benefit? Who was angry because A&P succeeded? Well, the smaller competitors, the mom and pop grocers, were obviously disgruntled by A&P's success, and so were the displaced middlemen. All those all those intermediaries that used to ship groceries from producers to grocery stores were out of a job, at least with respect to the portion of the market covered by A&P. So the federal government didn't let A&P's success go unchallenged. There were several stages of governmental opposition to A&P. I'm going to go through a few of them quickly so I can get to the main event, which is the Sherman Act prosecution of A&P. First, there were a bunch of state and federal taxes in the teens and 20s on large chain stores, including A&P. This served in part to neutralize A&P's price advantage over smaller retailers. The Robinson-Patman Act, which was originally and more accurately entitled the Wholesale Grocers Protection Act. This is back in the days before they branded legislation in a way to make it innocuous sounding. This was in fact what it was. It was a Wholesale Grocers Protection Act. It was designed to protect wholesalers. And here's a great quote. This is an actual quote from lobbyists supporting the Wholesale Grocers Protection Act. The concern that they expressed was that the rapid expansion of companies like A&P was taking money right out of the pocket of the producer and the shipper and giving it to whom? The consumer, who presumably didn't deserve it. So I think many of us in the room are familiar with the mysteries of the Robinson-Patman Act. I don't want to spend a lot of time on it because it's very complicated, but suffice it to say that in the words of Diane Wood, its fit with contemporary antitrust is very awkward. Because it was principally designed to protect small businesses at the expense of consumers. So let's get to the main event. In 1946, DOJ actually filed a criminal Sherman Act prosecution against A&P, the company, and also its leading executives. And it actually obtained criminal convictions of A&P's leading figures in mid-20th century America. Now, Tim Muris tells me that in those days, criminal convictions were not as big a deal as they seem today. You know, you paid a fine, then after a few years you got your voting rights back. But it is useful to remember that the Sherman Act is actually, including Section 2 of the Sherman Act, is a criminal prohibition. So what were the bases of the successful criminal prosecution of A&P? One was predatory pricing. Now, this is back in the days before we had the Brook Group test and before you had any sort of economically sophisticated view of variable cost, and there was, of course, no recoupment requirement either for a plaintiff. And nonetheless, the court found that A&P had violated the Sherman Act in part by engaging in predatory pricing. Now, Morris Edelman, who was an MIT economist back in the mid-20th century, pointed out that this was an absurd theory to level against a grocer because barriers to entry are not particularly high in this market. So there's never going to be a period of monopoly recoupment in which A&P would be able to force all grocers out of the market and then raise its prices to monopoly levels because there'd obviously be widespread entry. There's also a monopsony theory. Here the theory was that A&P was so big as a purchaser that it was able to get such great discounts from producers that those producers then turned around and took it out on the other grocery stores by raising the prices for their goods to those other grocery stores. It didn't take long before people figured out that didn't make any economic sense because you would imagine that those producers were charging were charging profit maximizing prices. To begin with, they weren't leaving money on the table with the other suppliers. So ultimately what you see in this prosecution, and I encourage anyone who's interested actually to go and read the district court opinion in A&P. It goes on for about 60 pages in F sub. You read a lot of rhetoric and very little economic analysis. And here's an actual quote from a DOJ prosecutor in this case. A&P should be guilty of a Section 2 violation because it sells food cheaply to consumers because it is a gigantic bloodsucker, taking its toll from all levels of the food industry. It's an actual DOJ prosecutor who said this. And it gets worse because the argument was actually accepted by the federal district court and affirmed on appeal in the 8th Circuit. There's also an attack on A&P for being vertically integrated. As I mentioned before, A&P had this affiliate called ACO, which was a purchasing agent that went around the country buying produce very inexpensively from producers. Sometimes it bought too much produce and it had a surplus. So what did it do with the surplus? Well, it had two options. One is it could throw it out, or it could sell it on the open market. And who would be the purchasers on the open market? Well, other grocery stores would buy from ACCO at market prices. They didn't have to buy from ACCO, but many of them chose to because they were getting a better price from ACCO than they could get from producers themselves. This was highly problematic to the district court because it didn't understand economics. It characterized these payments as unearned tribute. And throughout this discussion in the district court's opinion, you see not analysis, but olfactory metaphors. There's like this sense that these were not just bad transactions, but odorous, unjustified transactions. And then he mixed the metaphor a little bit and said that the transactions tainted the whole fabric of A&P's operations. But again, A&P was doing nothing wrong here. It was simply selling goods on the open market to third parties who were better off because A&P was selling those goods to them. So at bottom of the complaint was simply that A&P was more efficient in selling at lower prices than everyone else. That was ultimately the basis of the criminal conviction. I'm going to move quickly through the next phase of the story. To suffice it to say, the DOJ next moved to do what we often hear calls to be done to today's tech giants, was to break up A&P into little bitty parts so that it would stop being so efficient in underselling smaller grocery stores. Ultimately, that effort foundered during a change of administration, and the suit was scuttled during the Eisenhower administration. Settled, although the price of the settlement for A&P was it had to get rid of this purchasing agent that had caused so much olfactory stress to the district court. All right, in 1949, this is a 1949 Yale Law Journal note. And back in those days, Yale Law Journal notes, unlike today, were not actually attributed. You just said note, you didn't know who the author was.
That's right.
Very prescient retrospective on this case. So here are some observations. The district court in the A&P case never drew the line between predatory and competitive price cutting. The district court was wrong and sort of suggesting throughout, through the use of its various metaphors, that vertical integration is illegal per se. Then there was this Schumpeterian observation in this Yale law note that we live in an economy marked by creative destruction, and that's good for consumers, so we should be encouraging it, not discouraging it. And ultimately, the note concluded that what we see here with DOJ's prosecution is a disturbing contradiction. The Sherman Act is designed to protect competition, but in fact it's being used to harm competition through misguided prosecution such as this. So in other words, antitrust philosophy on display was a paradox, a policy at war with itself. Now, this is a trick question. Who wrote that 1949 Yale note? I'll just tell you, it's not Bob. Yes? Yes, Doug.
I'm going to say Don Turner.
Oh, Doug, very good. It was not anyone from the Chicago school. It was Don Turner. And the message here is that you don't actually have to be an adherent of the Chicago school to understand that economics is really important in antitrust analysis and should in fact be the guiding light. In fact, you don't even have to have been thinking about antitrust after the Chicago school arose to have that insight. Don Turner understood this in 1949. Don Turner, of course, later went on to be the head of the antitrust division in the Johnson administration, not known for its economic conservatism. The point here is that this adherence to the consumer welfare standard that Don Turner was espousing in his student note in 1949 should be a point of bipartisan consensus, but for some reason it is not. And that's now when we fast forward to what I call the deep doctrinal past, we are seeing, in Bruce Hoffman's terms, a disturbing return to the sort of unmoored antitrust logic that animated cases like A&P. So Lena Kahn has written this note, also in the Yale Law Journal. These days, these notes are much longer. Hers is 70 pages long. I think Don Turner's was about 20. She also, like the prosecutors in the A&P case, would condemn companies that price really low, even if you can't show any danger of recoupment later. Why? Because it's just unfair to smaller competitors. Where have we heard this before? This sounds a lot like the rhetoric that animated the A&P suit. the Lina Khan note also criticizes Amazon for creating its logistics empire that basically allows Amazon to share scale economies with its competitors. To her and to other populists in the antitrust debate, vertical integration is just problematic because it creates a class of customers who are also your rivals. Why is that a problem? Particularly since you're lowering the prices that your competitors are paying, and there's no antitrust theory of lowering rivals' costs. Well, so why is it problematic? Rhetoric. We get rhetoric about conflicts of interest, tarnishing neutrality. In the absence of fiduciary obligations, conflicts of interest is not a terribly meaningful concept. And again, it reminds us of the district court's basis for holding A&P criminally responsible. So very quickly, I'm just going to imagine if, I'm going to ask everyone to imagine if you were an antitrust lawyer after legislation is passed incorporating the new populism into antitrust law. What do you say when a client calls you up on the phone and says, hey, I'm Apple. I have this great new invention called the iPod that's going to put a lot of local record stores out of business. Can I launch it? Or let's say your client is Netflix and they call and they say, hey, we have a great cheap way of distributing movies to everyone. It's going to put Potomac Video and Olsen Books and Records out of business. Is that a problem? Or how about Amazon launching the Kindle? Is the Kindle a problem? It's going to be very bad for publishers. It's going to be bad for local bookstores. How much of a price umbrella should your client hold over all these little mom and pop businesses to keep them, to preserve their profit margins? All right, I'm going to close with one slide so that we can get to the rest of the discussion. But this slide is important. So we heard earlier when Commissioner Phillips mentioned the need to address calls for sort of a totality of the circumstances, multi-factor antitrust analysis. One of the factors that the populists propose that we all take really seriously in any antitrust case is whether the size of the defendant or the size of the proposed merger would have implications for the political debate. So, for example, in a Section 2 case or in a merger review, we should consider whether a failure to engage in antitrust intervention would tend to preserve, in Tim Wu's words, a long-standing influential oligopoly. Okay, well, so what could go wrong if that were part of the analysis in the antitrust case? Well, here are some things that could go wrong, because we have a president who believes that antitrust should be used as a tool for rewarding his political allies and a tool for harming his political enemies. Every single tweet or statement that this president has made about antitrust is all about politics. It's not about economic analysis. For example, he believes that the Sinclair Tribune merger should have been approved because that would create a much needed conservative voice for the people. But as he says, liberal fake news, NBC and Comcast gets approved, much bigger, but not Sinclair. The president missed the distinction that one of these was a horizontal merger and the other was a vertical merger. That didn't matter to him because he was looking at the analysis that Tim Wu was proposing, which was looking at whether a merger or form of conduct would have a beneficial or a problematic, from his perspective, effect on political discourse. Suffice it to say that just because Tim Wu and Donald Trump agree about how antitrust should be applied does not make them right. So I'm going to skip right through this. My point here is that we have a big tent in antitrust. We have lots of common values. We have lots of things we can disagree about too. You get Carl Shapiro and Dennis Carlson in the same room. They're going to disagree about a lot of things, but they're also going to be talking about the same values. Those are the values we should be preserving. That's George Santayana. He's the originator of this quote, and I encourage everyone to remember it well. Thank you.
Our discussant is Larry White of NYU Stern School. Larry, unfortunately, is on a tight schedule, so he's probably going to have to rush through his remarks.
All right, so here's my title, and obviously with a title like that, I need a disclaimer. No fish were actually shot or otherwise harmed, nor were any barrels damaged. All right, I'm going to have to go very quickly. You've heard the two presentations. They're very good. Here's the background. We've got this apparent rising concentration, apparent increase in exercise of market power, maybe, et cetera, et cetera. And antitrust is alleged to be part of the story. Here's what they do. You've heard what they've just found. And now let me just offer you a little bit of context. There may be a concentration problem, but the standard data don't tell us enough to really know because they're far too aggregated. They are not relevant antitrust markets, and banking is a good example. Here's rising concentration at the national level for banks. There are 1,000 ways to describe this. If it was bank holding companies, it would be even sharper and steeper. But Robert Adams at the Board of Governors has compiled local MSA or non-MSA county data going back to 1980. And for deposits, for small business loans, that's basically what you care about. And that hasn't changed. If anything, it's gone down. And Bruce Kobayashi tells me that there are studies that show similar types of phenomena, despite rising concentration, actually stable or decreasing local concentration in lots of other services, retailing, wholesaling, et cetera, markets. Are the reported levels of concentration worrisome? No, partly they're not for relevant markets, and partly they're at such a high level of like CR50 or even CR8, they're not very interesting. What about those increases in margins? Well, they could well be due to higher rates of IP, and I just came across these data just a couple of days ago that show the relative rise of rising IP relative to other kinds of investment. Are large companies more generally becoming larger? This is not an antitrust issue. This is a fabric of society issue. And the answer is there was a substantial decrease in the 80s as lots of large companies deconcentrated on their own. They spun off subsidiaries. The conglomerate boom of the 60s and 70s had turned around. And since the mid-90s, there's been only a very small rise in aggregate concentration, whether you use Fortune data, whether you use Forbes data, whether you use US census data, they're all saying the same thing. There may be a very modest increase as measured by employment. This doesn't get to things like franchising, where something like McDonald's is like 1/8 company-run stores, 7/8 franchise stores that are owned by somebody else. It doesn't get to contract employees, but still, I think it's telling you something. All right, the issue of small firms has come up, especially in John's presentation. And let me just remind you, there is a long tradition, political tradition, that I don't fully understand, that says small companies are important. You see it in antitrust as early as 1897, where among the concerns of the victims were of price fixing was small dealers and worthy men. Section 2, that eventually was strengthened by Clayton, by the Robinson-Patman Act, was originally part of the Clayton Act of 1914. The National Industrial Recovery Act was designed to help small businesses and put limits on cutthroat competition. Miller-Tydings Act, which was the original Federal Fair Trade Authorization Act, was really designed to help small businesses put limits on the discounts, and that, that was Robinson-Patman, and then put limits on the price cutting that could happen for larger businesses. The SBA, set-asides, etc. So, echoing John, is history relevant? He had Santayana, how can you not have Santayana? Robinson patent was, unfortunately, remember, it's still on the books. It is still a bad idea, so was Miller Tidings for the reason. RPM is a perfectly, rule of reason type of issue, but the kind of RPM that was being advocated in the 30s and 40s was a bad idea. Antitrust is certainly not perfect, and the 30s and 50s are not an era to be proud of, and John's discussion of A&P, I think, really brings that out. Structural issues can be, structural remedies can be a problem. Microsoft, to take Bob's case, Microsoft had no good structural remedy. I believe it was a good case. I think Microsoft went out of its way to lean on everyone it could to try to protect its operating system. I just would have fined them a large number and moved on, essentially establishing deterrence. That needs to be remembered in all of these types of cases. Deterrence matters, and I would have fined them and moved on. I think all the previous speakers, regulation has a lot of appeal for a lot of reformers. The trouble is, what kind of regulation, what are the goals, and can you be confident that your guys are always going to be the ones in power, and what happens when your guys aren't? And so, of course, be careful for what you wish. Thank you for the opportunity, Tom. I wish I could stay. I can't. I've got to get back to you. Thank you very much.
Anybody have a question?
No.
Well, I'm going to ask a question. Is there a way to make Section 2 of the Sherman Act useful, beneficial, or should it just be?
I'm not sure. I mean, my problem here is that you can't divorce the effectiveness of Section 2 from the remedies which are prescribed by courts, and it's very hard for them, for courts to understand where a market is going and to design the right remedy. I haven't thought about how I would redo Section 2. I mean, in earlier writings, Robert Bork said one of the ways of dealing with the Sherman Act was to declare it unconstitutionally vague. Maybe that's the way to handle it.
I'm going to give a shout out to Doug Melibid's Microsoft case. First, I mean, obviously the remedy wasn't as draconian as some sought, including the states. But it did produce a wonderful unanimous DC Circuit opinion, which is basically should be in every casebook for students of antitrust law. It also, I think, has had a useful deterrent effect on actors throughout the ecosystem. It created lots of good precedent that the FTC has in fact used in cases like McWane about exclusive dealing. And let's not forget that there were actually fines imposed on Microsoft, obviously not by DOJ, but there were fines imposed by the EU, I think either Japan or Korea, and there were follow-on private antitrust actions that I think led to billions and billions of dollars in liability.
Okay, all right, Doug.
Just a quick comment, really responding to Bob Crandall. I think there are two very separate issues. One is the issue of remedy, and I agree that's a really difficult one. And particularly in a case like Microsoft, where it was a lawfully acquired monopoly and it wasn't clear what the actual effect of the wrongdoing had been, but even in other cases as well. So, okay, maybe we do away with injunctive remedies. But I just echo what Larry White said and what John said. To me, the important part of antitrust law is not the disposition of the individual case. That's just two parties. There are hundreds of millions of business decisions made every day in this economy, and the real importance of antitrust is the signals it sends to decision makers around the economy about what's permissible and what's not permissible. So you have to look at it more, it seems to me, in terms of the legal principle articulation and deterrence functions than the remedy in the individual case. you care to comment?
Yeah, I would agree with you, but one of the problems might be that the deterrence in the Microsoft case was to deter Microsoft from being aggressively competitive, and it might have reduced consumer welfare by keeping them from competing more actively in some of the new markets. I don't know.
Okay, I think we need to move to the next panel. We're going to move right into the next panel.
For our next panel, this panel is called Multi-Sided Markets, Big Data, and Consumer Welfare. And we have two papers, one by Professor Michael Katz of the University of California, Berkeley. He'll be speaking on multi-sided markets, big data, and a little antitrust policy. And then we have a paper by Professor Douglas Melamed and Nicholas Pettit of Stanford's Hoover Institution on the misguided assault on the consumer welfare standard in the age of platform markets. Our discussant today is Professor Bruce Kobayashi, now at the Federal Trade Commission, and I'll be timekeeping for you all. The first paper is by Michael Katz.
I'm waiting for the computer. All right, so fortunately I do not have a train at 11. While I'm waiting for my computer to say a little bit. So in some ways I think I'm talking about one of the less interesting topics having to do with platforms. The so-called new economy, but I will be talking about the issues of big data. And in particular, I'll talk about an important but a limited range of issues with big data. So the first slide that you're not looking at will show a platform that has users A and B, or types of users A and B. What I'm interested in, think of like Google search, where what they're doing is the business model is based on collecting a bunch of information about users on one side, often users who don't pay to participate on the platform, and then using that information in ways that make the platform more attractive to the paying users on the other side, the side B. So if you think of Google search, right, they're offering search services to people for free. They're collecting a ton of information about you, or similarly with Facebook, when you're using it, and then that's valuable to advertisers. Okay. So I want to think of one where the platform makes itself more attractive to one side because it's got information about the other. So often we think about this as something like Google search with advertising, where you say because Google has a lot of information about its users, it can offer advertisers very targeted messaging, which they find is going to be more effective. But there are other ways you can use it too. You could have the information that actually allows you to design the product. So this is an issue that comes up, for example, actually with Netflix, where they're a platform, right? One way you can think of them is they're bringing together programming creators with programming viewers, right? People pay for Netflix. And one of the things Netflix can do is use the very detailed information they have about viewing habits in order to actually provide advice for what's the right kind of programming in which to invest. All right, so it can go well beyond just sort of promotion decisions, and also, of course, it could affect pricing decisions. Okay, so that's what I'm fundamentally interested in. I'm not going to get into things about the use of algorithms and whether you can have algorithmic collusion and things like that. I really want to focus on these particular cases of platforms that collect extensive user data, and that's at sort of at the core of their business model. Okay, so who cares? Well, here's why you might care for antitrust reasons, or when it comes to antitrust. So one, and notice I have a lot of things conditioning the start of this, because one of the issues, which I won't have time to get into, but certainly anytime you're looking at an actual case, you're going to have to ask yourself, are the requisite conditions satisfied for the information to really matter, for the data issue to be worth worrying about? But if they are a key input, and if you think about something like selling a lot of internet-based digital advertising, they are, and there's a lack of substitutes and they're not shared across platforms, then there can be a problem, potentially, or things that can raise issues antitrust would want to worry about, because there can be big economies of scale, a scope, and experience in collecting information, and all of that can give rise to concentrated markets. It's not saying that by itself is an antitrust violation, generally it's not, but it can create conditions where we may worry about antitrust violations. And it also can potentially really create what people refer to as the data barrier to entry, that an entrant doesn't have the data it needs to succeed, and the only way it can get the data is it's already successful, and so there's this chicken and egg problem it can never solve. Right? So that's one thing. It could set up market conditions of the sort where antitrust concerns arise generally. Now, turning more specifically, there can be conditions under which the data could give rise to various concerns about exclusionary behavior. Right? Either you have an incumbent that has a lot of data, user data that would actually be valuable to rivals, and it refuses to sell it to rivals. We'll talk about whether that's a good or bad thing in a minute. But anyway, it's a potential issue there. Or you could even imagine, and I won't talk about them today beyond what I'm about to say, situations where you could have predatory behavior where the predation took the form of charging low prices or offering really good products, whatever, beyond what would normally be profit maximizing, where the reason you're doing it is just to starve your rival of business or transactions in order to starve them of data. So at least in theory, those things could happen. Okay? So I'll talk a little bit about different forms of exclusion. Another thing that can come up is just data are an important input. You can think of them as important assets, so they might drive mergers, both the analysis of competitive effects in terms of potential anti-competitive effects and also efficiencies. Talk briefly about that. And then finally, I mean, data are different than other inputs, so people have direct preferences about them. You know, whether or not you're using their data, people also care about how you're using it and what it does to them, so that raises these issues of price discrimination and privacy, and in particular, I'm going to focus on privacy. So let's talk about exclusionary behavior. So as it says here, in theory, you might refuse to sell data to your rivals solely to prevent them from being strong competitors. Okay? And there's some people who would think that that should be an antitrust violation. That's certainly just generally the notion of a duty to deal. But there isn't a general duty to deal in the US, I think with good reason. I think there's some people who think there should be an exception for data, that somehow data are different. I think maybe there's this naive view that, oh, well, look, user data, you just get that for free as part of being in business. You're a successful incumbent. All this data comes along with that. Why shouldn't you be forced to share it? Okay. Well, the normal arguments we make, or the usual arguments against duties to deal, is you say, well, if you force the firm to share whatever it is that it's accumulated, it undermines the investment. Say here, it undermines the incentives to invest in data. Okay? Not only it undermines it for the original investor, because they say, why, it's not going to give me a competitive advantage, I'm going to be forced to share it. And it also undermines the incentives for the potential entrant. So we see this all the time in telecommunications with fights about is there a duty to deal in terms of sharing of facilities. All right, so people say, well, okay, facilities, at least I see that's real money. I think some people think data or not, but I think that's completely wrong. The fact is firms spend a lot of money collecting data. I mean, if you think about it, that's what Google search is, right? They're spending huge amounts of money to build up the user base and to build up the data they have, and it's not coming free. Okay? And if you start having a duty to deal, I think you'll have all of the same problems that we usually do in creating misincentives. There also, you know, it's not, the other thing I think is important to recognize, it's not just about saying, okay, you have a pile of data handed over once and for all, you know, Cardinal set a price, we're done with it. Okay, that'd be hard enough figuring out what the price would be, but you might think, okay, it's once and for all, we get it wrong, it's not that bad. But the fact is that when we're talking about user data, they often become stale pretty quickly. There are massive amounts of it. It can be formatted in all sorts of different ways, and there are different amounts that you can, or different dimensions of consumer behavior you record and store. And so there's actually just huge numbers of decisions involved. And so we talk about this user data, it's not like it's this one thing, or you've got a scaler for every consumer, right? It's a very complex process and an ongoing one. And so to start trying to regulate that and impose duty to deal, I think would just be a complete mess. Mandatory data portability, I won't say much other than it's a mess, because not that, you know, one of the issues comes up again, do firms do things like somehow they'll store the user data in a way the user can't take it with them. Now, sometimes that might not matter. Probably not a lot of people would say, well, if I switch platforms, advertisers won't be able to target me as well. Okay, most people probably don't care about that. They might even like that the advertiser doesn't target them as well. In my case, it'd be good because I now get ones aimed at old men, and it's kind of offensive or depressing, I guess, or realistic, depending on your choice of words. So I'd rather switch to another site that somehow thought I was much younger and more successful than I am. But anyway, there are cases, though, where not being able to move your data is a problem, right? If it starts storing your preferences in ways that actually gives you, recommender systems that you actually find beneficial. So you might think, okay, well, wait a minute, doing things that make it harder for people to move their data, storing it in non-standard formats, things like that, aren't those anti-competitive? Well, we know from the vast literature on switching costs that the competitive effects of switching costs are really complex. And I think where that leads us, you say, oh great, another economist going on the one hand. On the other hand, is I think the main lesson that comes out of this stuff is, look, this is not something that's just completely new. And that's, I think, actually the lesson for all of this stuff. It's not something that's completely new. These are issues we've wrestled with before in this area. They are really difficult issues. And people who think, okay, we need some sweeping rules to deal with user big data, and we need to just treat it differently, I think is wrong. I think unfortunately where we are is you've got to treat them with the existing rules, with all of their messiness, and it means you've got to look in real detail at specific situations, rather, as I say, than just have sort of these sweeping recommendations. Mergers, I want to say two things about it, because this is, I think, one of the, maybe the only place where I'll say I think there is something new to think about. So first off, what's not new? Well, fine, big data could be an important asset or important input that drives a merger, and it could be for pro-competitive reasons. AT&T Time Warner, and I should disclose, for those who don't know, I played a minor role in it, but I was a testifying expert retained by AT&T in that trial. But one of the big issues, or what AT&T said is one of the main reasons they wanted to merge is there were difficulties in terms of selling at arm's length of massive amounts of user data that DirecTV had. They know a lot about their users, what they watch, when they watch it, all sorts of things they're up to, maybe a creepy amount that they know about you. That could be very valuable to Time Warner in lots of ways in terms of marketing its programming or even deciding what programming in which to invest. As I mentioned, Netflix already uses that sort of information linkage. And so AT&T said that one of the main reasons they wanted to do the merger was because of what they saw as overcoming market failures in the market for user big data. Of course, there are other people, in other mergers, and AT&T, I think the issues tended to be different than that when people who objected to it. But you certainly could imagine someone asserting that a merger was designed actually to deny access of user data to rivals. You might preemptive, you could imagine an incumbent buys another firm that has comparable user data, and they buy them up in order to stop yet another firm from being able to use those data and compete against it. Or it might do it just to raise the price of it. Now, the thing is, well, you might think, well, these sound like scary issues, or they're new issues. They're not so new, because we have a lot of mergers involving intellectual property, and mergers that involve licensing. And I think a lot of the issues are largely the same. So in video programming, so this did come up in AT&T Time Warner, but people have have this issue. They say, well, you're buying this intellectual property, the video programming, and now you're not going to sell it at appropriate prices to your rivals. Well, it's exactly the same sort of issue that can come up with big data. So I think an awful lot of what's going on when you do have big data important in a merger really isn't that new. And I think we have experience to draw on, and again, we don't need a new set of rules. In fact, a new set of rules would be a bad idea. Now, as I said, there is one place where I think we could use some new thinking or additional thinking, and that is thinking about potential competition. Because my understanding of it, and certainly from what I've seen, suggests this is right, that it's extremely difficult to bring a potential competition case in the United States to say the reasons they were objecting to a merger is not because they're competing now, but they might be in the future, and that could be a big deal. All right, well, let's now think about it. In platform markets, particularly ones where having user data is really important in order to be able to compete, that's potentially this, the lack of data could be a barrier to entry. So, what do you do about it? I'm not a big fan, as you've heard, of having a duty to deal by the incumbent. So one thing you might do is if you figure out some other market in which you can accumulate a lot of user data because you're successful, eventually you build up enough of that, and also this can interact with network effects. You just generally have a big enough pool of users that you have the data necessary, and then you make a lateral attack. Okay? So you can think of that as a form of a two-stage entry decision, entry strategy. And so, okay, so if we're in that world, then you think about what could happen with a merger. Right? You say, well, we have two firms, they're not in the same market, they're not competing with each other in any sort of obvious way. But in the future there might, because this one is building up the database it needs, the user base it needs, in order to launch a future attack. And so if you let the firms merge, right, you let say the one that thinks it's the future is going to be attacked, you let them buy the other one, right, you're avoiding the competition between the two, and possibly you're avoiding Schumpeterian competition, right? It may well be that once they both have the database, they'd be fighting for the market, and it could be an existential threat to the current incumbent. I think a lot of people now, I think, and some people at the time, think that the Facebook-Instagram merger or the Facebook-WhatsApp merger were actually examples of this. Okay, the Facebook, or the competition between Facebook and WhatsApp or whatever is extremely limited at the time of the merger, but a lot of people say, look, this is the way you're going to overcome Facebook. You're not going to do it through a frontal assault. You're going to do it having an app that somehow is different. Eventually, you're going to have such a huge user base, then you can take them on. And I think this is something where we need to think more about it, because I think it is right that in a lot of cases, you're going to need to have some way of building up a huge user base. And the user base is often going to have to be somewhere else. And so I do think this is somewhere where we need to think, are there ways, how do we take this into account, because I think it's a real effect, but how do we do it in a disciplined way? You don't basically say a successful firm can't buy anybody, because anybody someday might be successful as well and compete against them. All right, competition and privacy. Let's go quickly, because I must be out of time. There's sort of two issues. A lot of people think, okay, big data, we really need antitrust to protect this because privacy sucks in the modern economy. I agree on the privacy sucks part. I just want to be pretty clear. I mean, the lack of privacy, the privacy protections we have, by that I say sucks, I mean are really inefficient, I think, or insufficient. Okay, so I want to be clear. I think privacy is a problem, but I also want to be clear, I don't think it's an antitrust problem, or one that antitrust is going to address well, and I want to look at two things quickly. One is what's the link between competition and privacy? So, would having more stringent antitrust lead to greater privacy? And then I want to very briefly go the other way. Well, what about privacy laws? What do those do to competition? And are privacy policies, public privacy policies, in sync or in tension with antitrust? So you might think, look, privacy is product quality. We shouldn't worry just about price. We should also worry about quality. So doesn't that mean antitrust should worry about privacy? Well, I think there's a warning there. There's two warnings. A warning there because as in a general matter, there's no theorem, no true and correct theorem anyway, that says that a firm with market power, that a monopoly undersupplies quality. Okay, we know there is one that says it undersupplies output, charges the price too high, but it's well established, okay, that a firm could set quality too high or too low if it's a monopoly. It's known as the Spence distortion among economists, as your economists know. And so if you think of privacy, you've got the same point. It could actually be the monopolist sets the privacy protections to be too stringent. Okay? So there isn't a general result the way there is with output, so that by itself tells us we should be cautious. Now, there are some things, some cases where you might think, well, wait, maybe there's more reason to think of a problem than usual. And one of them is when you have media platforms. And the way I mean that here is what I started out by talking about, saying there's one side that gets the service for free, and then the other side, so I'm using a subset of media platforms. One side gets the service for free because they're basically an input into the sale, say, of advertising to the users on the other side. Now, there I think there is a reason to think you're going to have too little privacy. And you can think of it a couple different ways, but one way is to think of it as a monopsony and monopoly problem. So on the monopsony side, the platform is basically taking its viewers, it's basically paying them to serve as an input. Okay, it's giving them some service for free, but that's really payment in kind because they're an input into the sale of advertising. So what happened then, you want to think about a monopsony, it says, well, okay, how are we paying you? We're not paying you in dollars, we're paying you in the service and the different attributes. So one of the ways to lower the price that we're paying you as an input into the sale of advertising is to weaken privacy protections. It makes it worse for you, but since the reasons it could be costly for us, that's what we're going to do. So we're going to exercise monopoly power on one side by weakening privacy. Now on the other side, weakening privacy can actually help you exercise monopoly power, because when you weaken the privacy, if consumers actually know you've done it and they care, you're going to have fewer users, you're going to have less advertising for sale, and that's going to raise the price of advertising. So there actually are reasons to think in these markets where they're advertising supported, that there, at least with monopolies, there is undersupply of privacy. However, once you get to competition, it turns out, there are models in the literature, you can have either undersupply or oversupply. Okay? And loosely you can think of it, the problem is because there's no pricing to consumers, the only way to compete may be you have these different firms to offer better and better privacy, more and more strong. And it may be that actually you would have been everyone better off if you just paid people instead. But since whatever reason you don't have the price mechanism, you're in the world of second best, and as we know there, generally things are a mess. Okay? So in the interest of having Doug go, even though the whole reason we're late is because he asked that question at the end of the previous session. But there's no responsibility in this country anymore. So let me just say,
I cede you my time.
let me just finish one thing up. I won't go through these, but I just want to say, going the other direction, there are a lot of ways that privacy rules can backfire on competition. In some cases, they can help. Right, so if consumers knew that all platforms had good privacy protections because the government was enforcing and mandating it, that might intensify price competition because it takes away a dimension of differentiation. On the other hand, taking away dimensions of differentiation can make it harder for new firms to come in and establish a niche. It also could be bad for consumers because consumers may have different preferences about privacy, and if you have strong enough government regulation, it could kill that off. So I just want to say that, and there are also various things with privacy regulation that can inadvertently promote concentration and a lack of competition, because the extent that you let firms share data within the firm but not across firm boundaries, you're creating an artificial benefit to bringing activities inside the firm. So these things can backfire. So just to sum up, I think it's important that we not overreact to this. I think there are obviously important antitrust issues, but I think they're largely ones that are similar to issues we already face. We have the existing tools. I think it's much better to rely on those tools, to rely on existing precedent and experience rather than try to create something new from whole cloth. And all of these, I think, we need to take exclusion seriously, but as always, we have to be very careful about it backfiring. We want to make sure we don't end up harming competition in the name of promoting it. I do think, as I say, the one place probably I think we need the most new thinking is just thinking about entry effects and this whole idea of, coming up, building up in one industry and then making this lateral attack across. And then how do we, I think firms can recognize that's coming. How do we then have policies that can recognize that without overreacting? That said, I think not just maybe a problem, I think privacy is a problem, not one though to address through competition policy. And again, just as I always have to say it, antitrust enforcement, it really needs to be highly fact-driven and case-specific. And just another way of saying the first point that I think we want to resist this trend is say, whoa, this is all new. We need rules, new rules. Off we go. And with that, off I go. Thank you.
So, this paper kind of came about by a kind of serendipitous series of events. Nicolas Petit, my co-author, who is here in the audience, was at Hoover last spring, and we met up and were having discussions about various antitrust doctrinal matters of interest. And somewhere in the course of that, Nicolas emailed to me an article in the CPI journal that Tim Wu had written criticizing the consumer welfare standard. We both thought it was kind of silly, or maybe not Tim's best work, I don't know how you want to phrase it, but so we wrote a short response. And then Nicolas said, that's only one strand in this multi-stranded assault on the consumer welfare standard from the sort of new Brandeis, new populist, hipster antitrust school. Why don't we try to write something that, at least at some level of generality, takes on the field? So we tried that. Properly?
And it doesn't work.
Doesn't work. All right. Then I'll put the glasses on and I will do this. What do you know? Okay. So what's the general concern? Obviously, there's a lot of conversation today. You guys all know this as well as I do about wealth, income inequality, concentration of economic and corporate power, and the resulting kind of concentration of political power. And that conversation always leads to somebody to start talking about antitrust, because antitrust is the thing that most people think is the tool we use to deal with economic power. All right. So critics of antitrust policy pointed to a lot of indications they believe of inadequacies in the policy. There are studies that purport to show the bad effects of approved mergers and increased industry concentration, which is many have noted industry concentration is not the same as market power. There are anecdotes about big platforms like Amazon, and then there's failed litigation efforts like American Express and AT&T Time Warner that some people think reflected problems in the system because they were purportedly good lawsuits. Okay. Specifically, many of these critics have focused on the consumer welfare standard, which is in many ways the foundation of contemporary antitrust law. They say it's flawed, that it biases antitrust law toward under-enforcement. In our view, to preview where Nicola and I end up, this view rests on a misunderstanding of the consumer welfare standard and would, if adopted, lead to some very bad antitrust policy. I want to make clear what we're not addressing. We're not addressing the larger political economy question that is there too much wealth inequality or too much concentration of economic or political power. We're not addressing the originalist argument that Congress in 1890 had a different vision of antitrust law. I'm not sure that it matters. First of all, one thing is clear from the legislative history, as I understand it, is they intended to incorporate a lot of the doctrines in the prior English common law. They wrote a very ambiguous statute that certainly would suggest a cleavage between originalists and textualists if they want to try to figure out what it means. And in any event, we've had 100 and some years of a common law tradition. I'm happy with that, but if others want to argue originalism, that's fine. Nor are we disputing that antitrust law can be improved. I'm going to come back to John Nectarline's Big Tent theme in a minute. We are arguing, though, that the consumer welfare standard is not the problem, that replacing it will not improve antitrust law. Okay, as we see it, you could group the criticisms of the consumer welfare standard into three categories. Conceptual ones, Tim Wu and I think Lena Kahn and others have said, consumer welfare is about maximizing welfare. It's not just about establishing rules of right and wrong, and the former is not, courts are not well suited for the former. Then there were, I think, of as the instrumental concerns. Look where consumer welfare standard has taken us, to a price fixation. We overlook monopsony. We've given short shrift to innovation and so on. And the third category are the doctrinal ones. Here's interesting, clearly two strands. One, Tim's article that I referred to earlier that would basically do away with a market power screen and have what he calls balls and strikes for the umpires to just focus on the conduct element. And others, Tim's book, I believe, in the other direction, says let's do away with the conduct element and just have a kind of no-fault monopoly law. So I'm going to talk about all of this. The conceptual criticism, consumer welfare antitrust is an exercise in social planning in which courts test conduct and whether it delivers a welfare maximizing outcome. This is just plain wrong. This is nonsense, frankly. Antitrust law is proscriptive. It is not prescriptive. Courts apply rules. They do not apply to try to maximize welfare, nor do they require companies to do so. The consumer welfare standard is a criterion used to inform the development and articulation of legal rules. It is not itself a substantive rule or standard governing conduct. It's like the patent laws. Patent laws are intended to promote innovation. With that North Star, people who think about what should the patent laws do argue about what kind of rules should we have, what should be the standard of novelty, for example, what should be the procedures. But you don't go to a court in a patent case and say, Your Honor, the position I'm urging upon you is I'm asking you to promote innovation. That's just not how the laws apply. The antitrust law is really not very complicated. There's two things in antitrust. All antitrust law, all U.S. antitrust law comes down to two propositions, two elements. One, did the defendant engage in conduct that is not efficiency-based competition on merits? And two, if so, did that conduct increase, or is it likely to increase the defendant's market power in the sense of diminishing the disciplining effect of rivals in the market? That's it. That's all of antitrust. There are a lot of little details per se and all, but that's what it's all about. And the consumer welfare standard basically enables one to use those criteria to inform the articulation of the antitrust, specific antitrust rules, instantiating those principles. By providing a rigorous criterion by which to judge the antitrust rules, the consumer welfare standard cabins the discretion of courts and agencies, reduces rent seeking, and thus enhances, it seems to me, the legitimacy of antitrust law. Okay. Instrumental concerns. I can't read that.
Supplement.
Okay. The so-called price fixation one. All antitrust cares about is short-term price effects. It ignores everything else. Well, I guess I know where it came from, but it's just so wrong. First of all, price is often a shorthand people use for other measures of value. We write supply and demand curves, but that's just, when I teach antitrust, I say the demand curve, think of it as a value curve. It simply shows diminishing value to the consumer with more quantity, and you can say a lot about welfare just using that simple picture without the word price. Lots of antitrust rules have nothing to do with price. Exclusive dealing, time, product design. Important critical cases. Microsoft had to do with free goods and innovation. It was a defendant in that case who said, if we really had monopoly power, our price would be even higher than it is. And the court said, no way. So the notion it's all about prices seems to me is simply wrong. It is true that a lot of antitrust decisions are handicapped when there's not good price data. And we think of the hypothetical monopolist test and all that. That is not inherent in the consumer welfare standard. That is a measure or a reflection of a practical problem, which is if you're going to learn about the world, if you're going to do it, you can apply economics. It often helps to have a metric by which you can measure and describe phenomena. It's very hard to talk about the unobservable, like future innovation, or the unmeasurable, like quality. So there is naturally, I don't want to call it a blind man in the drunken problem in that, rather than a lamppost, but there's naturally a practical problem where economists look to observable phenomena and metrics that make sense. That's not a conceptual problem with the consumer welfare standard. And by the way, it's one that can be ameliorated in two ways. First, by the development of new empirical and analytical tools, like those that were developed for merger analysis. And we didn't have unilateral effects analysis. We didn't have the hypothetical monopolist test long ago. People have thought about it. Now they're thinking about what do we do about zero-price markets? What do we do about innovation? What do we do about the two-sided platforms? And there's already a lot of learning being generated. And secondly, if we have areas where we're not going to be able to get observable and measurable phenomena in the individual case, maybe we should have some presumptions and some shorthands and some quick look techniques to resolve uncertainty without always defaulting to the defendant. But again, all of this can be done within the consumer welfare platform. Okay, the other one is a kind of, it's oversimplified economism. Everything is about these simple price theory models, and it biases antitrust towards the defendant, pointing to the Chicago School legacy. Here are the problems with that. Because nothing about the consumer welfare standard is biased. If the consumer welfare standard means rules that are likely to prohibit private conduct that diminishes economic welfare, I don't see that as biased one way or the other for a defendant or a plaintiff. The association with the Chicago School is historical. It is not inherent. We know that the law has taken account of lots of important post-Chicago learning, vertical restraints, game theory, information theory, and now some new insights from across the pond and from some people in this room about two-sided markets. Yes, the common law has a lag time. Time and work are required before courts replace outmoded understanding with new learning. Aaron Director took him 20 years between his insights and the GTE Sylvania case. So we're still working on maybe some post-Chicago developments. All this can be done within the consumer welfare paradigm. And more easily, by the way, than if there were new statutes passed to instantiate what someone might think of as today's knowledge, which will, like anybody else's knowledge, become obsolete soon. And the question is, how do you adapt the law to new learning? Okay, well, I'm going to skip the case study because I don't really have time to do it. In the paper, we do a case study on the American Express case, which is designed, first of all, to link all this up to some platform issues. But more than that, I think, although I hadn't thought of the terms, it's designed to address John's Big Tent notion, which is to say, look, even to us, who think that case was really badly off the rails, badly decided, and even worse, I'm not sure the decision, the reasoning I thought was horrible. Our criticisms are entirely within the consumer welfare standard. There's nothing about the consumer welfare standard that required the five-justice majority to do what it did. Quite the contrary, in our view, what they did was a misapplication of sound consumer welfare-driven antitrust law, but again, we'll say that. Okay. So the final criticisms, the final category of criticisms are what I call really the doctrinal criticisms. And then you have the Tim Wu's short paper, basically, let's get rid of the market power screen. All that does is create a likelihood for false negatives. It makes it much harder for people to prove cases. It complicates economic investigations. It makes them more costly, maybe deter litigation. Let's just have do's and don'ts. Now, number one, that could be done in the consumer welfare paradigm, but more per se, quick look and burden shifting. So again, that's not an attack on the consumer welfare paradigm. It's an attack on a particular set of rules we use to try to implement that paradigm. Now, okay, that proposed change would, of course, reduce the number of false negatives, but it would sacrifice a number of benefits that I think we're all aware of the market power element in antitrust, which is it screens out unimportant cases and reduces incentives to turn ordinary commercial disputes into antitrust cases. It reduces compliance costs. My favorite little example here is, we all know that bundled pricing is a kind of a dicey issue. It's not entirely clear what the right answer is. But it is helpful to have a market power screen so that McDonald's can know that it can offer a Happy Meal without worrying whether it's going to be sued for an antitrust violation. And of course, it does reduce false positives. And for those, like many of the populist new Brandeis who are concerned about new economic developments like platforms, digital age, zero-price markets, and so forth, precisely because they present new challenges that the likelihood of a false positive in assessing the conduct is going to be greatest, so it may not hurt to have a kind of belt and suspenders hurdle that the plaintiff has to overcome before predicting. And then finally, the other side of the doctrinal criticisms around the caveat from both sides is, but I think in some ways, I was saying at breakfast today to Nikolai, maybe we've in a way missed the point here. We got too much in the forest and missed the trees. I think in some ways what the critics of the consumer welfare standard are really saying, and they're really taking on board, they're saying, we've got to get efficiency out of antitrust. We've got to have it be about rivalry. Well, he can do it, I can do it. Okay. And so what we ought to have is basically get rid of the conduct element. Because it's the conduct element that allows people to say, oh, wait a minute, this was not inefficient conduct. I built a better mousetrap. Get rid of that. Just say if you're a big, enduring monopolist, break you off or hamstring you, say you can't merge, merge. Okay. Again, within the consumer welfare paradigm, you could do this. You could have rules like that if you reached a judgment that the welfare benefits of reducing market power ex post were thought to outweigh the welfare costs of no fault intervention. It's not conceptually inconsistent with the consumer welfare standard. This turns on some empirical judgments I suspect most of us wouldn't want to make. But of course, you pay a huge price for that. If you intervene that way ex post, you pay a huge efficiency cost in terms of static costs by disrupting productive enterprises. If you had rules that in effect restricted efficient conduct that creates and maintains market power, you'd impose static costs in terms of loss of benefits of that conduct, including innovation and scale economies. and dynamic cost by reducing ex-ante incentives for both big firms and rivals to innovate and increase efficiency. And in addition to that, you're doing a no-fault, and I've asked Jim Wu this, and his answer was, at the time, he hadn't finished his book and didn't know. I haven't read the book, maybe he answered it. What are the criteria for no-fault? Are you gonna ask what's the amount of market power? How you measure that? The duration of the market power? Tim said, well, I think one thing I would do if I were doing no-fault is I wouldn't apply it in an industry or to a firm that is innovating. Okay, we should have no-fault intervention into the steel industry of the U.S., but not the platform economy. Doesn't make a lot of sense to me. Okay, conclusion. In our view, the criticisms of the consumer welfare standard are based on a misunderstanding of the standard and a failure to appreciate the benefits of it. And that the specific perceived problems with contemporary antitrust law are not inherent in the consumer welfare standard and can be corrected without abandoning it. The attacks on the consumer welfare standard, and I say this as someone, like a couple of you, written in the Yale Journal, Law Journal symposium this spring that kind of suggested, maybe nudge it a little bit to the left here and there. So even for those of us who think there's a need to improve antitrust law, I regard the attacks of the consumer welfare standard as a diversion from the important legitimate work. Those who think there should be a reform, in my view, should focus on a reassessment of the relative costs of false negatives and false positives and the empirical judgments of Easterbrook and so forth that we've all taken for granted now for 30 years and that may no longer be right in general over respect to specific circumstances. I don't know the answers, but worth thinking about. They ought to focus on developing new economic and empirical tools for dealing with these new issues and addressing the difficult problems of how do you measure and how do you illuminate things that are hard to observe. They ought to consider the possibility of new factual presumptions for resolving antitrust cases and quick look type tools. And they ought to educate judges, not just about the learnings from the 1970s, but about, again, drawing on the Amex case, the need to analyze the facts and dispense with overly broad, outdated generalizations, such as that vertical restraints and mergers are always benign.
Transactions were gone. They were thinking about each other. I have 10 minutes for so. Thanks for the invitation. Two really great papers. I always forget to do this, but even Noah Phillips has to say this. So what I say are my own thoughts and ideas, and they're not the FTC's or the commissions or any individual commissioners. The one thing that I liked about Michael's paper was that I came away with it depends, and I think that's the nature of the problem we have and we face in antitrust today. Is that, as he said, everything's complex and everything is fact intensive. If you look at the way the Bureau of Economics looks at all the issues that they have to look at, that's what it is. I mean, you don't see people just saying, "Oh, the Herfindahl is," I think in a sense we have all the tools, as he said, to and have applied the same tools to sort of look at a lot of things that involve scale, involve data. I mean, we look at things where there's sale of data. I mean, we have pharmacy file buys. We look at those, right? We have, the FTC is barred from thinking about insurance, but we can do title insurance mergers, and there's data plus. So there are all these things. They have scale, network effects. I mean, they're not anything new. A couple of UCLA grads, Stan Leibowitz and Steve Margolis, they had things. I'm getting so senile I can't even remember good friends of mine. They've talked about all these issues, and I agree with Michael. None of this is really new. A lot of it is sort of things that we have to think about in the context that they come up. And so, I have really sort of nothing to quarrel about sort of his viewpoint. In a sense, it may just be that we're sort of part of the apparatus, and I would include Doug in that. And, you know, we've spent a lot of time, especially as economists, thinking about, you know, the difference between the marginal use value and the marginal cost of producing that unit. And that is, of course, the combination of consumer and total surplus. And I think Michael's one of the few antitrust people that have used that dirty word called total surplus and suggest we use that. But I mean, that's how economists deal with the value of a voluntary transaction. So I think it's great. I think the one thing that he didn't talk about enough is sort of the relationship between privacy and antitrust. I don't know if this poster was there. Ginger might have left it for me. But there's this guy, and he's holding up a barbell and says, the Bureau of Economics supporting the twin missions of the FTC, one being consumer protection. It's a really hideous, ugly picture, but, and the other being competition. And, you know, the FTC does privacy. We do it on the consumer protection side, and it hardly creeps into the competition side. And Michael has sort of suggested that, well, privacy would be just a dimension of attribute of the good, like a quality good, and he applies the Spence model, and he also then thinks about sort of the monopoly versus competitive provision of quality, or in this case, privacy as an attribute of quality. And you know, I think it's a good way to sort of think about how you would sort of incorporate those issues into an antitrust analysis. He also, as he mentioned at the end, thought a little bit about how you go the other way. We have in Europe GDPR. I don't know what that acronym means. I do, but I have my own thing for GD, but I won't say it here. But I mean, and you know, if you look at sort of some of our rules, the FTC's 2013 copper rule, it really looks, it's kids, but it really looks a lot like GDPR. And I think we're really interested in, and there are a lot of good work. Alexandra Acquisti has been scraping data for a couple of years just so he could sort of test the effects that these privacy regimes have on, you know, what firms do, how firms get funded, and things like that, and what effects they have. And I think there's a paper by Goldfarb and Tucker that you might want to read, where, you know, they say, hey, look, sometimes these privacy regimes are onerous in a way that sort of is like a fixed cost, and so that sort of pushes everybody to Google and Amazon, and it really does have sort of these structural effects that I think we want to think about more, and it is a really sort of important issue. I want to sort of now turn to Doug, because I think I'm 5 minutes in. So I think there's a paper by Luke Frobe, Mike Vita, Jim Cooper, and Dan O'Brien that's entitled something like Antitrust as a Problem of Inference. And so I mean, I think that much of what Doug, at least the back end of his paper with Nicola, is really talking about that. And Michael, to some extent, is talking about that, because when economists say, yeah, it's complex and fact-specific, that means we need empirical work, right? And I want to sort of talk about sort of distinguishing two things. One, and Doug mentioned, maybe we ought to have some presumptions when sort of the investigations don't give us much sort of direct evidence. And so I always think about any type of law enforcement as a problem of inference, and you have two types of evidence. One is what Bayesian would call a likelihood function, right? It is the probability you'd see this evidence given, let's say it's an anti-competitive merger versus a pro-competitive merger, right? And that just is the way that statisticians look at, well, the sort of strength or value of the evidence. If the likelihood function is one, it's valueless evidence, right? The probability we see this evidence under the two alternative competing theories, pro and anti-competitive, is the same. And so it's valueless. Doesn't matter if it both are 0.9 and 0.9 or 0.1 and 0.1. That's valueless in terms of you being able to distinguish between two things. And then you multiply that to sort of get your posterior probability by the prior odds. And the prior odds are, I think, serve the function in that equation. It serves the function of presumption, right? And certainly, we have antitrust presumptions. I mean, the most famous is the Supreme Court's presumption they announced in Matsushita. Everybody says you're mispronouncing it, but Kobayashi, Matsushita. The Supreme Court said that predation is rarely tried and even more rarely successful. And that's a statement of a presumption, right? And what we hope is those presumptions, and I think Doug mentioned this, are based on sound empirical historical evidence. I think you look, what was that presumption based on? It was based on Kohler's study and a bunch of other things, which, it's not a great diff and diff study, right? A lot of cross-sectional evidence. And so maybe today we wouldn't want to have sort of such a presumption. But I think that's one area in which we want to have empirical evidence. And what that requires is a lot of studies of conduct or mergers or whatever you want to look at and seeing what happened, right? And so one of the things that Chairman Simons and myself as the director are really interested in doing is continuing our work on doing merger retrospectives and trying to sort of figure out, of course, what happened. I mean, if we've been so lax, especially vertical mergers, right, for so long, there must be a lot of anti-competitive deals out there that, if we get the data and we get a credible control group, we're going to try and look at them and see if that's true. So that's one thing. I think it's very important that our presumptions are not based on sort of thin air. They're based more on sort of actual empirical historical evidence based on credible studies. And I did notice that you did sort of say that the problem with American Express is that they have some kind of cross-sectional study, and they didn't do a diff and diff, although you didn't use the word diff and diff, right?
No, I didn't.
Yeah.
I never used that word.
but I mean, I got that point. The second thing that you want to look at is sort of the actual evidence you have in the case, and I think that Michael is more talking about that. And when you have complex cases, I think really one of the things is that often you don't get good evidence to actually make a decision where you have a high degree of confidence that you're making the right decision. And so this is especially true when we go outside of where we're just looking at a retail merger, and we have Nielsen data to tell us, and natural experiments to tell us, at least a prediction of what is going to go on. I'm out of time. Who do I buy the time from? A lot of the issues I think that where people are unsatisfied, so I'll take just one example and then I'll stop, is potential competition, right? I mean, I don't know. We struggle predicting sort of traditional, static market mergers, right? I mean, it's still, no matter we have tools. Michael has, contributed to our first order tools, and we hope those things are doing better. But in the end, that's still a predictive and certain enterprise. And if you're going to tell me, right, we're going to look at, and I wasn't there, so I could say anything I want about this, but we're going to look at Facebook buying Instagram. Instagram had, 11 employees when they bought it, right? And, Instagram's really big. I'm not on Instagram, but my dog is. And maybe it was that Instagram was bought by Facebook, and Facebook invested in them. That's what made them successful. So it's really even harder to sort of figure out how you predict the effect of those mergers. And I think that is a lot, and that goes back to Doug's point. It's not really a conceptual thing. It's really a practical implementation problem. And, I think economists can serve to sort of try and figure those problems out. But we're not going to, we're not going to get that close in the near term. So we'll see if the frustration boils over and we all get thrown out on the street. All right, thank you.
Thanks for the panelists. To the panelists, do we have any questions? Maybe one question? Or among the panelists as well.
Thanks. I'm Mark McCarthy with the Software and Information Industry Association. I got a question for Michael on privacy and competition, our favorite topic these days. I wonder why you think of privacy as a positive feature of a business practice. I know we all value it, but some of us actually prefer to have a business who knows a lot about us to provide us with products and services or even advertising that's more targeted to our preferences. And so if that's the case, just assuming that privacy is a good thing and antitrust should somehow take that into account, there's another way of thinking about it, which is the way the FTC thought about it when they were looking at Google DoubleClick, which is that you can think of privacy as a sort of non-price dimension of competition. And so if there's a merger where all choice in the marketplace is removed, and that feature of competition is an important dimension in the marketplace, maybe the antitrust regulators should look at that. But that's really different from substantive privacy rules where we decide that privacy is a good thing and that the competition rules should support that.
Okay, one thing in my presentation is less careful than I believe I was in the paper, which is, I think a correct statement is we expect to see that privacy will be a good thing at the margin, and because to the extent that relaxing privacy is both cheaper and easier for the platform, makes the product more beneficial to advertisers or whoever on that side, and users like it. We would expect to see that level of privacy provided. And so when I was talking about incentives and things, getting those issues, it's always, okay, but what about them pushing it beyond that? Because you're right, there certainly can be a lot of consumer benefits to it. And so that's what I had in mind in talking about the incentives to get it wrong. But you actually raise a really good point, and I think I will go edit my paper, since Larry White's not here to hear me say I'm pulling it back so I can do that. It is important to take that into account if you start having government regulation and setting specific rules. And I said that actually very obliquely, and your question point that I need to be less oblique. When I said, as I was rushing at the end, oh, well, you've got to be careful because privacy regulation takes away the value of variety. It's maybe some consumers want high levels of privacy, and as you're saying, some would prefer very low because they do get better products. So I agree with everything you're saying. I just need to be more careful about expressing it.
So thank you. Let's say thank you to the panelists, and we'll have a 5-minute break.
Any of the stuff Bob said I was going to talk about, but hopefully I'll talk about something that might be interesting to someone, although I'm not sure to this crowd, but let's see. So I'm going to talk about attention platforms, which are these platforms that basically connect people and advertisers. These attention platforms, they basically buy our attention, as I'm going to explain, and they resell it to advertisers. Michael already kind of alluded to this. And what I'm going to show you is that in these kind of attention markets, content is really the king of the realm. We really need to be concerned about that. And time is the currency, which kind of helps us understand how these all work. So the first question is, why on earth should you want to spend 15 minutes of your time, valuable time, listening to me? So a couple of things, 4 things. So first of all, these attention platforms turn out to be a really big part of the economy. In the US, people spend more time on them than they spend working. 2 of the largest publicly traded companies in the world, well, they were. I'm not sure about today. These stock prices keep going up and down. So maybe they're like in the bottom 10 now. I'm not sure. But at least it was Facebook and Google, highly capitalized firms, make most of the money this way. Amazon is kind of on this way up in the advertising business. You've already heard today that they're subject of really intense scrutiny over privacy, data, anti-competitive practices. They have nicknames like Fang and stuff like that. And then finally, all of you are probably going to multitask, so you're not really investing 15 minutes in listening to me. You're kind of dividing it up among a bunch of different things. So let's talk about these attention platforms. So newspapers do it, Google does it, TV does it, so does radio. They all get people to spend time by, in effect, giving people content. That could be feature stories, it could be search results, it could be your Facebook news feed, pop songs, and whatever. And a lot of them give that to people either for free. Almost all the online platforms do that. And a lot of the other platforms, maybe it's not free, but in almost all cases, it's heavily subsidized to the viewer. And when you think about this, it's really kind of remarkable because these businesses, largely are operating on the content side outside of the price system. So there's this enormous barter economy going on in this country that's kind of operating in plain sight. And interestingly, when you think about all the content that we're all getting, that most of us are getting largely for free, none of that is really included in a gross domestic product. So we call these attention platforms, and basically what they do is they harvest your time because they're hoping that as a result of giving some of that time over, some of that attention is going to be available for them to make available to the advertisers. And what they do is they go to marketers and basically sell those marketers the opportunity to present ads. So if you think about the role that content plays in these attention platforms, it actually plays several really important roles. So first of all, Michael alluded to this, it's the payment for the time that could provide the attention that's being used as an input into providing advertising. So it's playing that important role as a payment to the viewer. It's the place. It's the place for inserting ads that could attract attention. If you look at any of these platforms, and there are some examples on the right-hand side of the screen here, it's the place where these ads get inserted so that people can see them. The other interesting thing that content does in attention platforms, it's the matchmaker. It's often the thing that is used to attract the right eyeballs to the right marketers. That's obviously the case when you think about Google search, but it's also the case when you think about Fly Fisherman magazine or many other kinds of content. And the final thing about content is that it's a very efficient way of running this business because in effect you're incurring a fixed cost to create the content and that content then attracts many viewers. Now this basic model, it's obviously a big part of the economy nowadays, but the basic model that I just described with those four features there, this goes back to newspapers originating in basically the 17th century, and that's been the model that we've had more or less for the delivery of advertising ever since then. And without a lot of modifications, that's what is being used today. Now, for these attention platforms, time is really the currency. So as I said, consumers pay for the content by providing their time. The platforms then exchange that time from consumers and they get money from the marketers. And then you have companies like Nielsen that actually monitor the flow of the currency in these businesses. And I think for some of these businesses, time or other proxies for time is sometimes actually referred to as the currency. And of course, marketers can't get attention unless viewers make this investment in time in the platform. Now, what I think is most remarkable about these attention platforms is just how much time people actually devote in them. So these data are from a paper I did last year that's based on Nielsen data for 2016. According to the Nielsen data, these are the data that is used in this industry to kind of track things. A typical American adult spends almost 9 hours a day watching, reading, or listening to content that has ads in it. That works out to close to 800 billion hours in 2016. Okay, well, like all of you are doing during my talk, actually, you seem remarkably attentive, but I see a few who are multitasking. And the rest of you who aren't multitasking are probably thinking about something else, so you're probably multitasking too. So you might argue that people aren't actually spending 9 hours listening to this stuff. So in the paper I mentioned, I tried to do, it's kind of, rough and dirty, but I tried to back out the amount of time that people are mainly spending engaged in this activity and not multitasking, and I describe how I do that in the paper. And when you do that, it works out to about 5 hours a day that people are mainly engaged in looking at these attention platforms that have advertising in them. And if you count that up, that works out to a little bit more than 400 billion hours. Now, if you compare that to how much people work, 2016 people worked 308 billion hours. So this is consuming a massive amount of the time that people have available, and as you all know, we only have a finite amount of time. So now, the interesting thing about time is that time has an opportunity cost. All of us could be doing something else. All of you could be doing something else instead of listening to me. You could be checking your email, doing billable hours and stuff like that. So time, people have a finite amount of time. And that time obviously has an opportunity cost. You spend a minute more on one thing, you have a minute less available on something else. So as a famous economist, once said, this is Benjamin Franklin, time is money. So you can always, do other things with that time. It has an opportunity cost. And one of those things that you can do is you can work. And that's a insight that Gary Becker took from Benjamin Franklin in 1965, and has a really interesting paper on how to go about valuing time. So, using that as kind of as an insight, I thought it would be an interesting idea to take these numbers here and see if I could do a kind of back of the envelope calculation of the value of the content that people are getting. And the basic idea is that if you're spending half an hour listening to a YouTube video, that's a half an hour that has an opportunity cost that obviously has some value to you. One way to place a value on that is to think about using something that is tied to a wage rate, just on the theory that ultimately everything gets tied back to the possibility that at the margin people could increase work effort and make some more money. So you don't necessarily need to believe any of the numbers that I'm going to show you. The only point of the numbers that I'm going to show you is to suggest to you the obvious point that if people are spending 800 or 900 billion hours a year on content, then that's a pretty big economic activity, no matter what number you multiply that by. So it turns out that valuing time is something that the US Department of Transportation has been doing for a number of years, because they do it in transportation studies, trying to figure out whether it makes sense to spend money on infrastructure that has one of the consequences of saving people's time. So they actually have a rule of thumb, and they use 50% of the median pre-tax wage to value time. So I thought I'd use that. Thought I'd take half of that. And if you do that, for the US, if you value all the time that I just showed you, that works out to close to $6 trillion. $3 trillion if you use 25% of the pre-tax wage. You can use any other number you want, and it will come up to a big number. There's also an interesting couple of studies done that attempt to use the time value approach to estimate a value of consumer surplus. So there's an older paper by Goolsbee and Klenow, American Economic Review, like around 2006 or so, that first implemented this to value free online services. And there's a more recent paper, 2011, 2012, by Bertelsen et al., that tries to apply the same kind of approach to value online as well as television. So I've done some manipulations of that paper, and you take that paper and it implies, using their figures and adjusting it for hours and stuff like that, something like $1 trillion in consumer surplus as a result of free content coming from these various sources. So again, you don't have to believe any of those numbers except to believe the insight that at some level this content is obviously extraordinarily valuable because people act as if it's very valuable because they invest their scarce time in it. Okay, so that's my sort of one punchline, which is these ad-supported media platforms, these attention platforms, are serving an important economic function in the economy that probably isn't really recognized as much in our national income accounts or anywhere else, for that matter. Okay, so maybe tying it to some of the points that we've all been talking about today, these attention brokers are two-sided platforms by the classic definition that most people use in this literature. They connect two different types of users, in this case, people and marketers. They facilitate exchange, they solve an externality problem, they're reducing transactions costs basically between the marketers and the consumers. I explain that in more detail in the paper that is associated with this. There are positive indirect network effects, at least in one direction. So advertisers value more users. Let's kind of put aside the other direction just for a second. And like all of these multi-sided platforms, they use the pricing structure in order to deal with that externality between the two sides. The common pricing structure for these attention platforms is to charge $0 to the viewer for the content that's being delivered, and to basically charge the marketing side. The one point that I want to make about these ad-supported platforms is, at least in the economics literature, at least from the mid-2000s forward, there is no debate that these are two-sided platforms. Coincidentally, I just see 2 minutes there. So, okay. So there's no debate over that. One interesting thing about these platforms is that, talking about the interdependencies, the two sides are interdependent in another interesting way. So viewers may not like ads. We can debate that, but everyone doesn't like all ads. But one thing that we can be sure about with these attention platforms is people may not like ads, but they really do like the content. And that content provision depends upon the marketer demand for being able to advertise to the viewer. So if you have more ad demand, you get more investment in content, you get more viewer demand, and so on and so forth. And that leads to a positive feedback effect, going from the intermediated by the content between the viewer and the advertising side of the platforms. Now, in conclusion, let me just tie this to the American Express decision. So there's this unfortunate language in the American Express decision. So the Supreme Court had this problem that they had to navigate their way around a 1951, I think it is, 1951 decision in Times-Picayune, which is a ad-supported newspaper in New Orleans, which I think is either no longer in business or it only operates online. But in any case, in 1951, it was an ad-supported newspaper in New Orleans, and there is language in that Supreme Court decision that analyzes the tying allegation in that case in a one-sided way. So the Supreme Court, basically being egged on by a number of people who said two-sided market, all decided in 1951, had to navigate its way around the Times-Picayune decision, and in the course of doing that, they picked up on the point that since there are no indirect network effects, arguably going from the viewer to the advertising side, in the sense that people may not really care about ads in newspapers, that you could do a one-sided analysis in that case. Nevertheless, for all intents and purposes, these attention platforms are two-sided. No controversy among economics. I'm hoping that Times-Picayune isn't going to stand in the way of that. And one thing I want to just point out for those of you who care about this is, so the one-sided analysis in Times-Picayune concerned a tying allegation. If you actually go back to the, am I seeing negative numbers now? So I'm almost done. I really am almost done. So the tying allegation was a one-sided analysis, but if you actually go back to the DOJ complaint in that case and other arguments in that case. There was also a predation claim. DOJ, the defendant, and the lower court actually analyzed the predation claim in the only sensible way that you could possibly analyze a predation claim in a two-sided platform. They basically treated it as a two-sided platform and did a combined analysis of the two sides. So maybe it's one-sided for some claims, but not one-sided for other claims. And then the final point that I won't spend a lot of time on now is once you dive into the details of attention platforms, I actually don't think that they're very different than the transaction platforms that the court talked about. So you can't have a presentation on attention platforms without an ad. So while I have your attention, I would like to suggest that if you have any questions on this or like to learn more about two-sided platforms, I have a book called Matchmakers, which you see an ad. Therefore, so I'll leave it at that. Thank you.
All right, thank you very much for having me. My name is John Yoon, and I wrote a paper with Joshua Wright, and it's picking up where David just left off in terms of the Supreme Court's Ohio versus American Express decision. But it was actually written before the decision came out, and we had to adjust it because obviously the court ruling is a big part of what people are talking about now, so we weaved that in. But what we were really interested in is there's a debate regarding how you treat platforms in antitrust in sort of the dirty business of product market and competitive effects and who bears the burden of evidentiary support, whether it's efficiencies or the harm itself. And what was interesting is I think there's a lot of closeness of both sides. There are some who are more extreme. Like Kim Woo has written an amicus brief, which is a little bit more extreme, but I think most are sort of in the middle. But you have to make a decision about which side you're on in terms of the bearing the burden, and that's what I kind of want to talk to you about today, and I'll walk through. So here's the basic setting. In 2010, the DOJ opened an investigation into all the sort of major payment card systems, Visa, American Express, and MasterCard, and MasterCard and Visa eventually settled with the DOJ. But what was the basic allegation? It's this practice called anti-steering. So if you're a merchant and you want to be able to accept American Express cards, you have to accept this anti-steering provision, which means that at the point of sale, you can't steer an Amex customer who pulls out their card and say, whoa, you could save $1 if you use your Visa or your Discover card instead. I save money because I don't have to give as much to Visa and Discover. I have this high swipe fee, is what they call it, to American Express. So let's sort of both win in this transaction. American Express says ex ante, you cannot take American Express, obviously. But you can't, once you take it, you have to agree to these terms. And so this was considered anti-competitive. And that was the allegation, and that was a Section 1 violation. So just picking up again where David left off regarding platforms, American Express is trying to bring two separate groups together, and that's sort of the key distinction here that the court made, and really makes it an interesting aspect of the case. There's cardholders on one side, and there's merchants on others, and they're balancing the interests of these two parties who want to unlock trade in a mutually advantageous exchange. The monetization is through interest payments from the users primarily, and the swipe fees that the merchants have to pay when accepting the card. Right? And with this monetization, you try to bring in more card holders with rewards, and that obviously induces merchants to accept the card. So at the heart of it are these cross-group effects. Are there cross-group effects? Unlike the attention markets that David was talking about, this would be considered, and I'll talk about further, a transaction market. And effectively what it is there's a direct interaction between these two groups. And so is there a cross-group effect, meaning as there's more card holders, does this attract more merchants? And the answer is yes, right? So you have a positive check there. And conversely, as there's more merchants who accept the card, does this, become more attractive to card holders? And the answer is yes. So you actually have cross-group effects going in both directions, unlike arguably in attention markets where it's only going in one way. So what was American Express's defense to this anti-steering provision. Basically, they're saying, look, you're advertising that you take American Express. It's on your window, it's on your cash registers. They show up, they try to use American Express, you steer them. So you're attracting our sort of group of cardholders and then harming the network at the point of sale. And so what this does is it gives a short-run gain to the merchants and to the cardholder, but it creates longer-term damage to the network itself. It starts to unravel as there's less transactions on the network. And additionally, they went down the list and said there was no reduction in output because of this practice. There's no evidence of a price increase. Only 20% of the market is American Express. So do we have that antitrust market power that you really need to have these types of cases go? And so that was sort of the heart of their defense. But what was really interesting to sort of commentators and practitioners in antitrust is how do you treat sort of these benefits to the other side, these cross-group effects, right? In essence, let me just jump right to it. In a rule of reason case, there's a three-step process. Step one, you have to determine if there's this anti-competitive market power. Additionally, you have to establish whether there's anti-competitive harm. And so at the heart of this debate is what exactly is anti-competitive harm? Is it harm to just one side or one group on a platform? Or is it sort of a net effect across all groups on a platform? That's at the heart of the debate. And so what does it take to satisfy this prima facie burden in step one? Step two is a pro-competitive justification, or the efficiencies defense as we would normally think of it in a merger context. And finally, step three is where you're weighing these two effects together. So what was the Supreme Court's ruling? I'll go straight to the language of the majority. Quote, credit card networks are best understood as supplying one product, the transaction, that is jointly consumed by a cardholder and a merchant. Accordingly, the two-sided market for credit card transactions should be analyzed as a whole. Simply showing a price effect on one side is insufficient to show anti-competitive harm, if you read the decision. They really focused on the output evidence. Output of credit card transactions increased during the relevant period, and the plaintiffs did not show Amex charged more than its competitors. As you can see from the graphic, this was a divided opinion. There was a strong dissent. Was it Breyer who wrote it? And they really, sort of attacked some of the points that the majority made. And I think this just points to the difficulties of this issue and what was really at stake. It's not that we think cross effects are unimportant on one side and important on another. It's about how do you incorporate that into the three-step burden shifting process. Okay, so there are two possibilities starting with the relevant product market. You could have two separate product markets, one for cardholders and one for merchants. Alternatively, you could have an integrated market approach where it's the payment card system is the market. Right? And that latter one is what the court ultimately decided. For competitive effects, there's a similar divide that you could have. You can have separate effects. You can show anti-competitive harm by just showing harm to one group. In this case, it would be merchants. Alternatively, the second possibility is what we would call integrated effects, where you can't show harm or meet your first burden just by looking at merchants. You have to look at cardholders' welfare as well, because they share a common output and they share these cross-group effects. And so you can't look at that separately. And that was sort of the second school. And the Supreme Court also went with possibility two. So we can sort of, in a broad way, and this is going to be crude because various scholars are not going to fall easily into one group or another, but just for exposition, we would say school one is where you keep them as separate markets and separate effects. Whereas school two is you can have integrated markets, or even if you have separate markets, you should have integrated effects always. And that's sort of the argument that we're making in this case, is that school two, we think, is the most practical to navigate platforms in an antitrust setting, a court setting. And so I'm summarizing the two here, but I'll walk through that as I go through these slides. But the point I want to make is the separate markets school doesn't suggest, at least most of them, that cross-group effects are unimportant. There's still an acknowledgement that's incredibly important. Now, some do say that you shouldn't incorporate that into defining the market, but again, I think that's the minority in that group. And the same thing for competitive effects. Okay, so the real issue is harm to one side sufficient to meet your burden of showing anti-competitive harm? And one of the points we raise is, in other areas of antitrust, we acknowledge that just because one group of consumers is harmed doesn't meet that burden. Price discrimination would be an example of that. You could be harming one set of consumers, but benefiting others, and often the welfare is ambiguous. An efficient merger could eliminate an inefficient competitor. Now, we would think that's a good thing, but in a differentiated product space, there's going to be certain consumers who really like that product, even if it was an inefficient competitor. And so they'll lose that option. And so they would actually be harmed from that merger. But again, we're looking at the net effect. So how should we measure consumer welfare in this setting? Well, when you have two sides, you have, in effect, two prices. And that's also a difficulty. And as Roche and Tirole told us, it's really the structure of prices that dictates the level of output, not the level of just one or the other price in isolation. And so since you can't show that consumer welfare is damaged, even on one side, let alone both sides, by looking at just one price, the idea of saying, look, let's just look at the effects primarily on one side here, in this case merchants, is sufficient for us to meet that burden. I think that's where the literature, I think, points us to say, well, maybe we do need to take a totalitarian approach, sort of in the aggregate of both groups together, rather than just focusing on one. Certainly, just focusing on the price of one would not be a good thing. Okay, so what are some of the pros of the integrated approach, which I've sort of kind of already mentioned? I think it explicitly incorporates cross-group effects. Again, this isn't to suggest those who argue alternatively don't want to incorporate cross-group effects, but I think this naturally leads to that. And when you define separate markets, that can lead to perhaps some awkwardness when you're trying to maybe integrate competitive effects at the effects level, the competitive effects level. I think that creates a little bit of a tension. I think it's really consistent with profit maximization. This is something that Ratliff and Rubenfeld wrote, that when you have this integrated approach to looking at platforms in an anti-competitive context, it makes the most sense because firms are maximizing over two prices. And it's different from complements. It's not sort of the analogy that the dissent focused on the complements, saying, well, you could say the same thing about complements. And I think those are a little bit different. And finally, output is consumed, as David has written previously, jointly and unseverably by two different types of customers. And I think that's really critical. The idea of defining two separate markets and certainly two separate effects doesn't make sense when they're sort of related in such an unseverable way. And these are quotes from David. You can never go wrong quoting David on platforms. And this is from his 2003 paper. There's no meaningful economic relationship between benefits and costs on each side of the market considered alone. One cannot talk about individual prices in isolation, since any change in demand or cost on one side of the market will necessarily affect the level and relationship of prices on all sides. Ultimately, any analysis of social welfare must account for the pricing level, the pricing structure, and the feasible alternatives for getting all sides on board. And I think that reality, to me, I think just makes the most sense to go with this integrated approach. Okay, so let me jump to some of the challenges with the integrated approach, right? It's not going to fit perfectly. I don't think either school or approach has like slam dunk arguments on each side. These are difficult issues, and it might depend on the specific type of platform or case we're dealing with. Identifying cross-group effects and even defining a platform came up in the decision. Like, what is a platform? economists, we don't have a canonical definition. I think there's some good ones floating out there that really get at heart of the issue, but there's really no accepted definition. And so if there's no accepted definition, how can we then throw it into this separate antitrust bucket, if you will? You can have different market shares across the two different groups, right? How are they in the same relevant product market if advertisers face different constraints as users face different constraints? And I think the response there is, I think that is the reality, and maybe it does make some sense to sort of talk about those separately. And the idea here is that relevant markets serve the competitive effects analysis. It shouldn't be that the competitive effects analysis serves the relevant product market, and I think that would be sort of the response I have to that. What is the price of the integrated market, right? If there's one sort of market, it's composed of two prices. I guess you can do sort of this aggregate price or a structure of prices, but I think, again, there, it makes the most sense to move to output to look at changes in welfare. Okay, so what are the takeaways from the Amex decision? I think regardless of whether you think the burden should be in step 1 or step 2, these cross-group effects are incredibly important. However it's incorporated into the analysis, it needs to be incorporated in that. I think it's very difficult for me to overcome the literature in saying that looking at harm on just one side of the market is sufficient to meet that anti-competitive harm burden. I really think you just need both sides. And then output, as I've been harping on, is I think the most clean measure in measuring welfare changes in this context setting. We usually use price because price and output move together and one is effectively measuring the other. But when you sort of have two prices and one output, that sort of splits, and I think you need to go straight to output in that case. Thank you very much.
Okay, my name is Ginger Jin. I'm a professor of economics at University of Maryland. I want to thank Tom for giving me the opportunity to read the two wonderful papers in a pair. Both of them address this key question: what is the antitrust standard for platform economy? As Dr. Katz has mentioned in the last panel, I think we really have to think hard about this question, and that's what these two papers do. They correctly identify one important issue in this question, which is market definition for multi-sided platforms. John has done excellent summary about the different schools of thoughts, whether we should just focus on one side or taking two or more sides all together as an integrated approach. I think that's an excellent summary. I think relatedly, there's a question of what are the relevant players in addition to the relevant markets. I'm going to come back to this in my comment. John mentioned the distinction between transactional versus non-transactional platforms. My understanding is that, for example, credit card network will be a transactional platform because there will be direct transaction between merchants and consumers. However, attention platforms like David has covered will be non-transactional because you don't have a direct connection between consumers who are searching on Google versus the advertisers who pay Google for advertising. At least in the paper, Josh and John seems to propose that for transactional platforms, we should take an integrated approach. For non-transactional platforms, we are okay with a separate approach. But I think David is trying to say that attention platforms are very are taking a big share of our economy, and because of the indirect network effects, that's even those non-transactional platforms should be taken from both sides. My personal view is that in practice, it's probably hard, sometimes will be hard to distinguish transactional versus non-transactional, especially if you consider the situation where maybe consumers and advertisers do not have direct interact in terms of traditional transaction, but they're sort of yielding their data to the advertisers. For example, if you're thinking data and attention is kind of the currency here in addition to the traditional dollars, then whether it's a transactional or non-transactional is really a blurred line. So I think it's from the economics point of view, if this is a platform with 2 or more sides with very important indirect network effects between those sides, my view is that probably we should always take them as an integrated entity to think about their business model rather than sort of going through the slippery road of which one is transactional, which one is non-transactional. I think I totally agree with David that when we look at price or non-price effects, focusing on money alone probably is too narrow, especially in today's world. Time is money, data is money, efforts is valuable, and there could be a lot of non-price effects in not only output but also in content, in privacy, in people's view of quality of the product they're consuming, and also in future choices that will come out in the market. So I think all that probably should be under antitrust consideration, as I think the current practice is doing. I have 4 comments. I want to have a disclaimer here that I'm going to provide those comments from the economic point of view. I'm not going to comment on who should do what at what step in the legal system. I think that's not my expertise. There are people in this room probably much more qualified to comment on that question. So I'm just going to focus on the economic side. I think from the economic point of view, it's no-brainer that we should consider market size for multi-sided platform. However, the question is exactly how we define that. If you read the, say, Rothschild and Turow, their definition seems to emphasize first, those networks should have network externality, okay? And second, there will be a effective cross-subsidizing between the different sides. Typically, the platform may prefer to subsidize one side and then charge on the other side, and sometimes it could be 0 price on one side, just like attention platform that David has mentioned, and sometimes could be even negative price, like in the American Express case where the credit card actually reward the cardholders for using their card. So from the academic definition, the emphasis is on the indirect network externality as well as the cross-subsidy between the different sides. However, if you look at the Supreme Court majority opinion on Ohio versus American Express case, they seem to emphasize 2 sides offer different products to different group of consumers. They both depend on the platform, and this dependency is simultaneous. We can probably play some wordsmiths on the English, but it's not clear to me that the Supreme Court opinion is very much aligned with the emphasis of indirect network externality in the academic definition. So I think this might be a practical question of exactly how the future cases would interpret the Supreme Court decision on American Express in terms of what is a 2-sided platform. Should every firm, even if they're just a wholesaler buying things from producer and sort of pass through that to consumers, would that be counted as 2-sided platform, or you need more narrower and clearer definition on that? I think that's a probably important question when we talk about exactly how broad the Supreme Court opinion would apply to future cases. A related question is, even if we identify this platform as a 2-sided or multi-sided platform, should we always apply this American Express decision to that? I'm going to quote David's previous writing on this. This actually is a quote from the Supreme Court decision on this. It says, in some cases, the fact that a business can be sought as 2-sided may be irrelevant, but in other cases, the fact that a business is 2-sided would prove important both by identifying the real dimensions of competition and also by focusing on sources of constraint. So that seems to suggest that even if we know a platform is 2-sided, maybe when we apply that to antitrust, it should be case specific. I think that's probably important question for people in both law and economics to consider. Are we done just with the definition of two-sided platform and always apply that integrated approach, or it should be a case-specific approach that sometimes we should consider all sides and sometimes not. So that's my first comment. My second comment is related. We talk about market definition, I guess with the assumption that players in those relevant markets will be the relevant players. However, for example, in the American Express case, I think the case actually is more complicated than that. Let me show you what I mean. So we talk about the cardholder case that say American Express and Discover compete for cardholders. Okay, that's the cardholder market. We also have this merchant market that they can carry one or both credit card, they can accept one or both credit card, and that's the merchant market. However, there's a third market here, which is the direct transaction between consumers and merchants, and they're actually a different group, so-called other shoppers who use debit card or use cash payment. They're not in the card holding market, and they're not in the merchant market. However, their welfare will be affected depending on the anti-steer provision of American Express or other card networks. So I think in that sense, that's not only in my view, that's not only should we consider the merchant market and the cardholder market, we probably should also consider the welfare generated by this provision or deterred by this provision in the merchandise market. So that's my second comment. The third comment is, okay, it's no-brainer we should consider all size, but exactly how to consider it, right? Should we just do a simple sum, or should we do weighted sum? Should we require there must be a harm occurring to all sides before we claim there's anti-competitive harm in this case, or harm to one side is enough? Unfortunately, I don't think the Supreme Court actually weighed in clearly on this question, and they sort of stop at this market definition stage. And related to my comment about this other parties that not in the cardholder market, not in the merchant market, but will be directly affected by the provision discussed in this case, should their harm or benefits be counted in the total integrated calculation? Okay. My last comment is, what is the right counterfactual? I think dissenting opinion sort of talk a little bit on this. From the economic point of view, what do we observe? We observe the practice of American Express, Visa, and MasterCard have this anti-steering provision. Okay, we observe some price outcome, we observe some quantity outcome, we observe some history of competition, like Discover trying to get into this market, but not very successfully. What we do not observe is what will happen if American Express does not adopt this anti-steering provision. Or more broadly, what if no credit card network adopts anti-steering provision? Then from the theoretical point of view, we know that's all the outcome I just quoted above would change, right? The price would change, the quantity would change, the nature of the competition would change. If you're interested, I would encourage you to read a recent paper written by my colleague Dan Vincent and his co-author Morris Schwartz. In that paper, they consider exactly a market like this, and they conclude that because of the anti-steering provision, you actually would have this arms race. That's every platform would have incentive to raise the merchant fee and give part of that back to the card holders, and the competition actually would compete to increase the spread between the two. Remember, the spread is actually the profit of the network. So they conclude that there's no pure strategy equilibrium in that competition, just because everybody would have incentive to really keep on raising the merchant fee and then kick some back to the cardholder. So if that is the counterfactual world we should think about, then the existing facts, for example, we see a fast growth of credit card usage, is probably not really the right counterfactual, because they could be encouraged, they could be a result of this anti-steering provision, because if I do not have a credit card, I basically sort of carry the harm from this provision, and therefore I sort of will rush to get a credit card, even though that's the result of that is everybody is raising the merchant fee, and therefore the merchandise price might be higher because the cost, part of the cost coming from the merchant fee. So I want to pose this question here. I think this is a very important decision from the Supreme Court. It's going to have profound implication for the platform economy. I think it opened a lot of questions. I would encourage both academics and non-academic people in this area from both law and economics really think hard of this issue. It will be great to see more debate and discussion on this decision. Thank you.
I think we have time for a couple of questions. Doug? I guess this is for the entire panel.
Yeah, I guess this question in a way is for the entire panel, or certainly the first two speakers. I'm going to state two propositions, and just the question is, I'd like your reaction to it. Proposition one is that perhaps not in a snapshot perception, but if you consider after the dust settles, I hate to use the word equilibrium because I'm out of my depth, but in some substantive way, in many, most, maybe almost all cases, there aren't going to be harms resulting from the conducts that are going to be the subject of antitrust questions. Harms on one side and benefits on the other. I could spend time elaborating, but the shorthand reason is because these platforms depend on both sides flourishing, and if one side isn't flourishing, the other side is going to be harmed, generally speaking. Okay, that's proposition one. Generally, the direction of good and harm and benefit is going to be the same on both sides. That's proposition one. Proposition two, if proposition one is correct, and if the task of assessing harms and benefits on both sides in those few or rare cases when they go in different directions is very difficult because of the difficulty of finding a common metric and then interpersonal comparisons and all that stuff, that maybe in the shortness of life, the optimal rule is to say, let's just look at one side, look at the net impact after we take into account feedback effects on the other side, and call it a day.
So let me take that. So I think it's a good question. It's a good question, Doug. And I think a more intelligent debate, both going into the Amex decision and the briefing of it, would have been more sensibly organized around the issue of error costs and the right rule and stuff like that. It frankly wasn't. There were stark alternatives that were presented to the court, and I think a lot of the things that you've just raised really were not raised. But I mean, the issue of the possibility of error costs and administrability and so forth, I think is an interesting topic. I have a recent paper out on that, and I agree with that conceptually. In terms of where we are, and I think where I fundamentally disagree with you is in terms of where I think we should be, is I want to start with your second point, which is I don't accept that this is all that hard. I've had cases for years now. I've had cases on the plaintiff side. I've had cases on the defense side. The reality is, in terms of doing a proper analysis of a lot of these issues for platform businesses, is it hard? Yes. Is it harder than a lot of the other complex cases that we encounter? Not in my experience. I've done cases where I've calculated two-sided price effects and output effects and so forth. And I think it's, again, I don't want to trivialize it, but it's not like this area is that much harder than any of the other complex areas that we encounter in economics. And then going back to your first point, I think where there is a disconnect between how those of us on one side think of this and how people on the other side think of this is the following. The basic point of the majority decision in Amex and a lot of the things that I've put forward is that if you want to understand competition among platforms, you have to recognize that there's interdependent demand, and you have to recognize that the platforms are competing with each other They're jointly maximizing over prices and output and all sorts of things on both sides. And there is no way to have a sensible conclusion on something as anti-competitive unless you're doing a full analysis that includes the both sides. And that was more or less one of the main conclusions in Amex, which is these platforms, these card networks, are competing with each other over both sets of consumers, and extracting one group where there's interdependency, really doesn't make a lot of a sense in terms of analyzing the competition issue. So, I mean, the final thing I guess I'll say on this is, obviously going forward, we have this decision. It says a bunch of stuff, and we're going to need to apply it. And I think an awful lot of the energy now should really be going into figuring out how we take this decision, bring it down to how we handle individual cases. And I guess I'm optimistic that this decision provides at least a starting point for an intelligent application of what is now a very extensive literature in economics on platform businesses that can be used in these cases. And I don't think at the end of the day we're going to have problems applying it. Nor do I think that this is a pro-plaintiff or a pro-defendant decision.
Does anybody else want to weigh in?
It's still Michael Katz, but I should disclose I was the testifying expert retained by plaintiffs in U.S. v. Amex, so come as no surprise to people. I think the Supreme Court's decision is terrible. And I do think it's terrible, but I want to distinguish something. I actually, I'll say this now that it's all done, there's ways I could have imagined the plaintiffs losing that case where I would have said, well, I thought we were on the right side, but I understand why we lost, and fact finders have to make particular decisions. I don't think that's what happened here. I think if you look at the Supreme Court case, and actually I disagree with David on this, I think it's very much pro-defendant because the Supreme Court cited a lot of literature, but it completely miscited it and misused it. And I actually think they made up the facts. But I'm happy to talk about people that separately. The particular thing I want to talk about, though, is this point that John made, and I thought you did a very good job of summarizing in a neutral way sort of where the debates are. But the one thing that troubled me was at the end you were saying, okay, well, look, there's this problem. We can't use a single price to capture just one side, but we also can't use a single price to capture both sides. The whole point of the literature is that the structure matters. And in fact, you quoted David Evans on that. So we all agree with that. So you said, okay, we can't do the price, so let's do output instead. But as Ginger pointed out, output has the same problem. You can't escape the fact that there are two different sets of customers. Their interests for certain things go in opposite directions. And that, and you mentioned normally we say, well, look, we can look at prices because price and output move together. But presumably what we really care about is how these things move with welfare. And as Ginger said, in two-sided markets, and particularly when you're talking about anti-steering provisions, can well be the case that the output level moves one direction and the total user surplus, taking both sides into account, moves in the other direction. So I guess my question for you, and I think it's not much of a question, more of a challenge, is why do you think the output test then is a good way to do things? And I take it you mean an output test, I want to distinguish one other thing, where you actually try to determine the effects of the conduct. I mean, the output test done, for those of you who should look, the Second Circuit, I have an article about it where the editor made me put the quotation in because I paraphrased the Second Circuit, and he said no one would say something that stupid. And I said, yes, they did. The Supreme Court's a little smarter. But even that, the quotation it put up was, well, look, credit card output has gone up over the last 4 decades, so obviously there's not a problem. Well, the economy has grown tremendously. There is no theorem that says monopolized markets grow more slowly than competitive ones. It's about levels, not rates of change. But I take it your test, I'm not accusing you of that, but I also want people just to know that the logic the court used was nonsense. There's actually a more legitimate debate about if you look at the change in output actually due to the conduct, but even there's this question. So I was wondering if you could address that part.
I appreciate the comment, Michael. I think, going to maybe like a Thomas Aquinas' first principles, what is it that we're trying to really measure is, as you mentioned, changes in welfare. But that's very difficult to get out, so we often use price and/or quantity as a proxy for that. And so the primary point is price, as we all agree, is going to be very difficult in a two-sided setting. So it naturally raises the sort of profile of output as a viable alternative. But as you suggest, just simply saying output didn't change, I agree. That was sloppy at best and wrong economically at worst. But that doesn't mean output in of itself is a bad measure. It's how you measure it, and as Ginger mentioned, what is the counterfactual? And if we're going to do it properly, we need to do that. Now, whether that's easy or hard, one can speculate. I think, David's had a lot of experience in this area. I don't know, but finding counterfactual is difficult even outside of the platform context. But assuming we can do something close and we're doing the right exercise, I think that's a reasonable framework to get at a proxy for welfare. Does that mean we ignore prices or we don't look at prices at all? I don't think so. I think that can color the analysis and we can also bring that in. But I think the primary thrust should be the right counterfactual output. And I think that makes a lot of sense, at least from my perspective, but maybe not.
Well, I think we need to move on because we're only a little bit behind schedule, but thank you very much.
Okay, so make sure that everyone can be out when they expect to be out. We'll start our last panel, which is 40 years after the antitrust paradox, which Commissioner Phillips mentioned this morning. And so this year, 2018, marks the 40th anniversary of the publication of the Antitrust Paradox. It's thought to be one of, if not the most influential works on antitrust in the 20th century, certainly among the most, probably the most cited work. This panel is not meant to celebrate or condemn the book, but discuss its influence on antitrust policy over the past 40 years, what it got right, wrong, what we should change going forward. The panelists, I'll just very quickly, we have to my left Tim Brennan, who's professor of public policy and economics at University of Maryland, Baltimore County, and a senior fellow with Resources for the Future. He's worked at the Antitrust Department in the US and Canada and advised many countries. Susan Creighton, who's a partner at Wilson Sonsini, and she co-chairs the firm's antitrust practice. Doug Melman has spoken already, so he's professor of law at Stanford Law School, but before that spent 43 years in the real world. And we have Tim Uris, who's a George Mason University Foundation professor of law and senior counsel at Sidley Austin, and has been chair of the Federal Trade Commission. Now, I told panelists that we wouldn't have opening statements and not to do presentations. So I thought I would start off by annoying everyone by doing one myself. I'm actually not, but I just wanted to start off by something a little bit broader that is relevant today because it sort of fits into all of the panels that we discussed. So just this morning, The Economist had an article. And so I don't know if anybody's seen it yet. And, oops, I didn't mean to open that. Let's start the presentation. There we go. So I'm going to just read a couple paragraphs from this article, take a minute, just be patient, and then I'd like the panelists to respond to it. So this is just from today in The Economist. Roll forward 80 years and competition regulators take refuge behind legal definitions of types of misconduct such as price fixing. If you ask them whether economy-wide dynamism has ebbed, they often insist that there are no analytical concepts or satisfactory data that allow that question to be answered, rather like medieval geographers who refuse to consider any evidence that the world is round unless it is written by members of the church in ecclesiastical Latin. And then, this learned helplessness reflects the tricky legacy of Robert Bork, an American scholar judge who wrote The Antitrust Paradox, a deeply influential book published in 1978. It correctly criticized blundering state intervention in the 1960s and 70s and pointed out that many big firms were efficient and many concentrated industries competitive. But Bork went further and argued that there was no logical or empirical link between competition, profits, and concentration. He also wrote that, when assessing takeovers, it did not matter if consumers were damaged by higher prices and less supply, as long as firms captured enough profits from efficiencies so that in aggregate both were better off. Bork's view of real firms has aged badly. He described the dynamism of Detroit's car makers before Japanese rivals exposed them as lazy and dangerous, and criticized AT&T's breakup, which became a triumph for consumers. 40 years later, the economy has changed. A battery of new studies link concentration of profits and falling wages. Intellectual property, not physical objects, is where the action is, and tech has created networked business models. Since 1978, total profits, that is corporate free cash flows or the money that firms make after paying for investment, have risen from 1.9% of GDP to 4.5% of GDP. It is sensible to ask why competition is not bringing earnings down to earth and what might be done to boost it. So I feel like we spent most of the day kind of talking about this, but I think that is 2 or 3 paragraphs about what people were talking about today. So reactions, even though I know what your reactions are. Reactions.
Yeah, let me start. Yeah, it's beyond silly for lots of reasons. First, we've compared now to 20 years ago, and you know, we live in the most dynamic change. My grandfather died at 93 in the 1980s, and he lived through an extraordinary amount of change. You know, when he was a little kid, there were no cars, and think of everything that changed. But that change occurred in a relatively slower period of time than many of the changes that have affected us have occurred. You know, you watch a movie from the 90s and you just look at how different it is. You know, they don't have smartphones. They don't have cell phones, period. You know, laptops, just everything. You know, Amazon's not delivering their packages. The Silicon Valley doesn't exist in the way it exists now. So that's point one. Point two is that Bruce Kobayashi and I wrote this article published a few years ago about Chicago School, and it starts out, and we come both to praise and bury the Chicago School of Antitrust. And the praise is easy, as we said, because the Chicago School had a lot to do with the revolution. But the revolution is now over 40 years old. Bork's book, this book, is really not written and published in 1978. As he says at the beginning, this book really should have come out in 1971. And most of what he wrote which is in this book, except for an important chapter we'll probably talk about later, had already come out in the 60s. The Chicago, one of the main points of the article Bruce and I wrote was the Chicago giants, as we call them, were like 1776. They were a band of revolutionaries who existed to overthrow the Ancien regime, but they didn't agree on how to run a government. If you just take merger policy, for example, Bork and Posner were at opposite extremes. Posner, and throw Baxter in there, Posner and Baxter believed in much more concentration screens than Bork did. Bork's rules were much closer to the rules of today. And those guys disagreed on all sorts of things, to the extent they even thought about it. They weren't focused on running modern antitrust policy. They were focused on getting rid of what they thought was the junk. So to ascribe Bork as having this kind of influence today is just wildly, wildly inaccurate.
Yeah, I think that you have to disentangle Bork. Bork has a huge legacy today. People still talk about him. They're not willing yet to leave him in the past as timid counsel. And I think that's because of the normative component of Bork's book and his thinking, where he made, I think, enormous and deservedly deserving contributions. One was that economic welfare should be the single objective of sound antitrust law, rather than a hodgepodge of political and populist objectives thrown in. Two was the importance for economic welfare of productive efficiency, even more so than allocative efficiency, something that post-Solo, I guess everybody takes for granted, but wasn't taken for granted in the antitrust world, I think, before then. And even when assessing horizontal agreements. And the third was that many of the prior cases went astray because they didn't heed those two basic propositions. So I think that's an enduring lesson, and that's why people still talk about the book. The problem is there also endures some empirical propositions not the normative ones, but the empirical ones that a lot of people continue to believe, some of whom I believe are justices on the Supreme Court, and they're just, nobody in the state of Illinois believes them anymore. These include the antitrust law should, this is, by the way, I went back and looked at the book to refresh myself on what Bork actually said. These are all things he actually said. Antitrust law should ignore all vertical mergers and all vertical restrictions because they're always benign. Come on. Single monopoly profit theory is unqualified. 3, ease of entry and ease of exit are symmetrical. 4, vertical agreements cannot be harmful to competition because if they were, the trading partners wouldn't agree to them. 5, single-purpose agencies like the Antitrust Division and the Federal Trade Commission always push principles too far. Just a note on that. I turned out the lights on Inauguration Eve in 2001, and as is a custom, there's a little farewell party for the senior guys walking out the door. And my sort of off-the-cuff farewell address basically said, I've thought about why it is that the people in this division are so wonderfully dedicated to the public interest. And my hypothesis, and I still believe it to be true, my hypothesis was this. If you're a believer in civil rights law or environmental law or whatever, you probably, and you're on the prosecuting side, you probably think your job is to push it as far as you possibly can to achieve whatever particular goal that law has in mind and wait for external constraints like courts and police or whatever to limit it. But if you're a believer in antitrust law, post-normative Bork, you believe in markets. And you don't want private restraints that impair the functioning of markets, and you don't want government regulation that impairs the functioning of markets. So you're looking for that Goldilocks sweet spot in the middle. And if that's what you're doing, I don't think that even this 5th proposition, that you can't trust single-purpose agencies because they'll always go too far, is correct. In any event, leaving that one aside, there's a lot of just economic nonsense that endures from Bork. It was thought to be correct at the time. It was very insightful at the time, but you know, it's been 40 years and we've learned it's just not true.
If I can just add one thing, Bruce, as Bruce and I point out, it wasn't most of these propositions. There's one that's a public choice proposition, which I'll leave alone. The economic propositions were not agreed even within Chicago. Chicago invented raising rivals' costs. They just thought it was empirically trivial. Ward Bowman was the first person who talked about problems with variable proportions and in vertical tying was his example. The Chicago literature is full of problems in vertical areas. So even within Chicago, they didn't agree with Bork on vertical. So I think to say that even when this book came out, that some of these statements were widely accepted economic propositions, I think is incorrect.
Yes, so I just wanted to mention, maybe as that article reflects, I do think there's a tendency for kind of a caricature of the antitrust paradox, as though it's like just, you don't need to read the book because you can just sort of assume it's like one great big stop sign that says stop having antitrust enforcement. And I think it's important to actually take, whether one sort of agrees or disagrees with particular or sort of very particular empirical propositions that were thought to be true at the time that are not, but what was sort of the larger project that he was engaged in. And in his own terms, he said his views were not prescriptions for the non-enforcement of the antitrust laws, but rather for their enforcement in a way that advances rather than retards competition and consumer welfare. And I really think that it's that proposition. I sort of dug, when you were talking about sort of criterion of like, what is it that antitrust should be about? I think having that proposition that enforcement should be directed at ways that advance rather than retard competition and consumer welfare, that's really the proposition that is the basis for his enduring legacy. And contrary to, again, sort of another caricature is that he was just sort of all about prices. I think to the contrary, the 60s and 70s against which he was reacting and which were the genesis of his sort of strong criticism was in fact a long history of the use of antitrust laws for anti-competitive, anti-innovation purposes. And I don't, at least within mainstream antitrust, I don't think that that's not a Chicago school view of what antitrust had been about. I mean, here's Herb Hovenkamp, for example, saying, for large parts of their history, antitrust laws have worked so as to undermine innovation competition by protecting too much. Antitrust policy often has reflected exaggerated fears of competitive harm and responded by developing overly protective rules that shielded inefficient businesses from competition at the expense of consumers. That's what Bork was reacting to, and that's what he was sort of saying, consumer welfare he was putting forward as the criterion by which we should be advancing antitrust rules that further consumer welfare rather than harm it.
Just a couple of things. First, I feel a bit at a disadvantage in that I went to look at my copy of Bork before coming here, and I think I have a first edition paperback, and when I picked it up off the shelf, it basically fell apart. So I couldn't like skim it to check the quotes and things like that as some
Did
of
it
the
fall
others.
apart because you read it so many times, or because you haven't looked at it and it's just?
I probably haven't looked at it in a while. I read it a lot when I first got it, but that was 40 years ago. When I was started at the Antitrust Division during their little-known, middle school honors program. Just a couple of things on the quote, and then just one quick reaction to what's been said. First, on the Economist quote, I kind of agree with Tim Muir's. I don't know what the counterfactual is, and the second is I agree with John earlier, is that not everything wrong with society is an antitrust problem. If you think that it's not a dynamic thing, maybe we should fix the education system, maybe we should do more to subsidize innovation, R&D, whatever. I just don't know I mean, there are just so many things, and to just sort of lay it all the hands at antitrust in general and Bork in particular just seems kind of, to quote a panel member, silly. The other thing it does say on and this may come up later, on what I think of as the Bork legacy and the Bork contributions here is simplicity and clarity. I think that's why it's been so cited, and because I don't think that, at least when I was starting to learn this stuff back in the late 70s, when I went to go work at the division, that there are a lot of things that had happened. There's a lot of stuff to read besides this. It wasn't, it was kind of like a useful, handy thing, but it was so clear, and it was valuable for that. And I think that simplicity and clarity are undervalued virtues. To probably disagree with Doug, I think overly broad generalizations, something he said in his earlier talk, have some value because to try to be specific is not a costless venture. Probably to the happiness of some of the people in this room, it's not a costless venture, but we can talk about that perhaps more later.
So there a couple of things that are maybe, I wonder how you square. So on one hand, there was little agreement even within the Chicago school on certain aspects of this. And on the other hand, the book should have been published in the 1970s, or at least, he started writing all of these in the early 70s. So, what was the trend up until that time? Did this book, did it represent a real sea change in the way people thought about it? Or was it just, he was clarifying what had been said up to that point, and it continued sort of a general trend towards a consumer welfare standard?
Well, if you put Bork in his right place and time, which is the 60s when he started writing, he's obviously a giant and important figure who influenced the debate enormously. If you just take the rule of reason and where the Supreme Court was headed, the Supreme Court was beginning to do all of this per se analysis. And if you read, I read him in law school, the two articles he did in Yale, the two parts on the rule of reason, they're monumental. They're still required reading today if you want to understand the origins of the rule of reason. And they had and continue to have an enormous influence on the way jurisprudence is done. And the Chicago methodology which is a methodology which he violated with some of his conclusions, but the Chicago methodology was rigorously empirical. If you spend time around the Chicago economist, as I did as a growing up, and I went to law school at UCLA, which was in those days a branch with Harold Demsetz and Armin Alshin, who taught in the law school. And, they paid him more money. And Bork at that time was extremely influential, and the ideas in the book were, and those ideas triumphed, and the methodology still. I think this is Susan's point. The methodology still triumphs today, and that is extremely important. But what I'm saying, and what Bruce and I said in this article, what needs to be retired is this. Talking about the Chicago School this, the Chicago School that. I mean, Phil Areta's treatise, and Harvard, if you want to call it, had as much to do, heck, look at Steve Breyer, has had as much to do with the development of modern antitrust law in the last 30 plus years has so-called Chicago School people.
Yeah, so this is a little bit different from your question, maybe. So I wasn't, I'm not, was not, and am not an academic, so I couldn't really tell you kind of in terms of kind of the course of the history of antitrust thought, but just maybe at a more practical level. I mentioned earlier that Bork was about correct focus of enforcement, not under enforcement, and two themes in his book are that where I think we can see a really profound change in terms of prioritization, is in what should the antitrust agencies be focused on in their enforcement efforts. And there were two things that Bork focused on. The first is he thought there was significant under-enforcement of price fixing. And so in that, people forget that one of the major defenses of his consumer welfare standard is that he said, if you're looking at all of these other factors, then you can't have a per se rule against price fixing. So, he wrote, if other goals such as small producer welfare are admitted, cartel price fixing cannot be illegal per se. A defense is possible and a full trial is necessary in order to weigh the interests of producers against those of consumers. And in this regard, I thought it was really interesting that one of the FTC hearings, I think it was last week, might have been the week before, Barry Lynn, actually on one of his panels, is on sort of the merits of consumer welfare. He was doing the mirror image of Bork. He was following his critique of consumer welfare to its logical conclusion, and he was criticizing what sort of the other branch of enforcement that Bork devoted a whole chapter of his book to was misuse of government processes for anti-competitive purposes. And Barry was saying that a big problem with the FTC and to a lesser extent DOJ's enforcement efforts is we should really allow all these little guys to engage in cartels. It's okay for real estate agents and travel agents, and I assume lawyers and doctors, to have, we're all small producers, and so cartels, should be okay. And I think Carl Shapiro, for example, on the panel was like, well, how do you tell a good cartel from a bad cartel? And I think more or less the answer was, I know it when I see it. So if we're going to start throwing open the discussion about consumer welfare, I think the consumer welfare standard, I think we need to appreciate that we're going to have to also consider, as Barry Lynn was being honest about doing, do we still believe in per se price fixing, for example? Because that's a major landmark consequence of the consumer welfare standard and Bork's legacy.
Do you think some of that is related to what Tim was saying about simplicity and clarity? I mean, saying that under enforcement of price fixing is a clear statement. Does that fit into the framework that the simplicity and clarity framework, or is this sort of a more subtle thing that you picked up on?
Well, I think he was writing about it quite clearly as saying, I think there's under-enforcement of price fixing, and you can't have enough resources if you're busy, sort of imposing per se, resale price maintenance cases. You're not focused on price fixing, but also that there's a conceptual issue there about, what kind of defenses can you admit? If there are other political and normative factors that should be taken into consideration, what's the intellectual basis on which we say price fixing, sort of, again, Doug had made the point that the consumer welfare standard is a criterion. It's not a legal rule, but the per se legal rules follow from that criterion.
Yeah, I think Tim's point about simplicity and clarity is very important, rhetorically, not in the substantive way that Susan, I'm not saying not in the substantive way, but in addition to that. For one thing, we're celebrating the 40th anniversary of Antitrust Paradox as if it was a watershed event. As Tim pointed out, of course, it had a lot of antecedents. One of those antecedents was the GTE Sylvania case, which was decided before this book was published and clearly reflected a realization by the legal community, at least the Supreme Court, a percolation of a lot of the prior thinking and all of this, if you pardon me, the Chicago School thinkers. But I do think that this book became important because when I read it, I thought it was a tour de force because it was so clearly written and the conclusions followed so clearly from the premises. And I think if you actually look at law and economics more broadly, if you ask why, for example, has Posner been more influential than some of the other law and economics folks, I think it's because his are the simplest and clearest ways of expressing it. He takes price theory and says, I can explain everything. Now, of course, he can't, but it sure looks like he can. And so I do think there's a lot to be said for simplicity and clarity in terms of the rhetorical and persuasive force of these presentations.
So then, the impossible question to answer is, would we have ended up in more or less the same place with antitrust even without the book? It would have taken longer, or what, Tim? Since you're the one who said we don't know counterfactuals, answer the counterfactual.
Well, what makes that, when Bob Crandall was talking about, some innovation things and whatever that, would it have been even worse had Bork not been around and that sort of thing. What's hard for me to know about that, just to kind of dodge the question even further, is a kind of Peltzman sort of offsetting behavior argument, which is that, that suppose that the consumer welfare standard hadn't come along in some sense. I don't know whether that's an even imaginable, there's any way to say that imagine the world were different than it is kind of statement. But if antitrust were still a kind of incoherent mess that Bork was trying to change it from, then, and we had these problems, especially in comparison to other countries and so on, that maybe we would have, done other things to try to correct for those that weren't part of the antitrust realm, and that's completely impossible for me to say. Well, I might hope that it would, but I have no idea.
I think Bork was essential. His reputation is in conservative circles is so wrapped up in what happened, what happened with the Supreme Court, but his narrow reputation in antitrust is extraordinarily well deserved, and it really stems. The book crystallizes it, but those articles and the debates he engaged in the 60s were very early in the attacks on the fuzzy thinking that was going on, and he buried the silliness of the Brandeis Chicago Board of Trade rule of reason where everything counted and therefore nothing mattered. So if he hadn't existed, somebody would have had to invent him.
It would be a chaos today.
So there was some discussion a little earlier about the role of empiricism, sort of post-Bork, and when I was first thinking, well, right, that's clearly a big change, and then I was still thinking about it a little bit more, and before this, we had the structure, conduct, performance paradigm, which can be empirical. And Luke Frobe has talked a lot about the lack of empirical evidence on antitrust still. Is it really the case that, controlling for how much easier it is to do empirical work now than it was in the 50s and 60s, is the analysis are the analyses that are used more empirical now than they were before, or do we just pay attention to them more? Because it wasn't like empiricism was completely lacking then, and it's not like it's so great now.
Yes, it's more now. But it's not perfect either. No, just think of the, you wouldn't condemn a merger on the basis of a casual observation about a trend to concentration or an 8-firm concentration ratio. You'd want to know a lot more facts, and I think that's clearly where antitrust is going.
But the Chicago analysis was rigorously empirical, which is one of the the crazy attacks on it is so wrong. It was empirical in two senses. Aaron Director, who's the father of all this, and who only wrote one thing, but Bork took his class, and Director taught with Levy. That's the only article he ever wrote. But Director inspired all these people to go read records of cases, and they wrote articles debunking the theory of the case. And there are lots of famous articles that did that, and they created, collectively a lot of data points. The other kind of Chicago empirical evidence that's so powerful, you can see in multiple places, but two in particular are advertising. Stigler won his Nobel Prize for saying something, ludicrously obvious, but I guess a lot of Nobel Prizes have been won for that. He said that advertising is a powerful tool for the elimination of ignorance, and there are lots of empirical studies that that show the benefits of advertising. When economists and lots of antitrust lawyers were running around saying how bad advertising was, and the concentration debate shifted like nothing else in the history of antitrust shifted on the basis of one conference and one book. The conference was, I can't point west, wherever west is from here, about 20 miles from here at the Early House, which is why I had our retreats there, incidentally, Susan. I had our staff retreats there for when I was chairman. And at that conference, it was set up as if the Chicago people and the people who believed in concentration were on one side, when it was really 80-20 in the economics profession. And after that, within 5 years of that book, the profession had switched. Nothing like that has happened in antitrust history, and it was a bunch of empirical papers. Harold Demsetz wrote this great little empirical paper, where he showed that there was this belief that concentration was a problem because it was correlated with accounting profits, and Demsetz showed, well, if that was true, then small firms, should be, you should find the effect with small firms, and if efficiency was the reason, he devised a test using the models these guys used, and it showed that efficiency explained what was going on, not if you believed accounting profits, not concentration. And then Franklin Fisher and others, Fisher obviously hardly a Chicago economist, wrote other great papers and books about the problems. But that was Chicago economics with empirical analysis at its best.
Yes, so it does seem to me that although there were certainly empirical studies before, I think what Bork maybe sort of at least thought what he was doing was emphasizing the primacy of economics as opposed to making economics one among other competing, sort of ventures. So, the economists might be saying this thing, but, there's other factors and that you want to be looking at. So when I first read Antitrust Paradox, it was actually not the first version, it was the second version. the second version had just come out, and he had a new introduction there. It was called The Passing of the Crisis. So this is, I think, by the mid-90s. And he himself kind of made some fun of his the first edition of the book. He said, he had struck a note of Teutonic gloom in that book. Sort of the new introduction was called The Passing of the Crisis. And what he's, what he was describing as the crisis was, he said, that it was no longer the case that the decisive, if disguised, political content was driving antitrust decisions, and instead, if there were mistakes made, and I'm sure he would include mistakes he himself made, they seem to arise from mistaken economic analysis rather than an egalitarian ideology. So I really think that more than anything else is what he stood for, and why he's now the center of the critique. That people who challenge that view and think we should go back to the good old days when egalitarian ideology could trump whatever those economics papers purport to say, that really, I think Doug made that point earlier, kind of in a different guise, about sort of, it's all about market power, and then, who cares whether it's efficient or not?
I'll just say quickly, I don't think of the Antitrust Paradox as an empirical book, particularly. If I had to surmise something, I would guess that the empirical effect was that the plaintiffs now had to do something. There wasn't just a matter of just, waiving a concentration thing or something like that, and in some sense that it, created this intellectual framework where if you thought something bad was going on, you really had to show something, because the presumptions basically had flipped for reasons that people on the panel have said.
There's no particular reason to wait for questions, so Drew, hold on one second. Ashley's going to call your phone.
Thank you. Drew Clark, Broadband Breakfast. So I want to kind of get you to focus on a specific industry, or really set of industries. And obviously today and really broadly, all the oxygen's getting sucked up by this discussion of platforms and tech companies, the GAFA or whatever it gets reduced. But it is interesting to see how the arguments have shifted very, very recently. Just a few years ago, there was a lot more criticism of the power of the big broadband companies, the Comcast, the AT&Ts, Verizons. And obviously this is an issue of strong concern for myself. And this predecessor of this organization, of TPI, when many of the people associated with, were affiliated with Progress and Freedom Foundation, that was of course a major player on the front of the Microsoft case. And talking a little bit earlier about that case and how it relied on the consumer welfare standard. But I'd really just like to get the panel's take on this issue of how easy market entry is, and how that should factor into the calculus about what kind of market power antitrust remedies need to be attacked. I mean, versus either the tech companies that are being talked about here today, or the broadband companies that became the subject of the concerted push on net neutrality 2 years ago.
I'm not sure I'm going to answer the question fully, but just to say two things. Notions of entry, it seems to me, are hugely important, not only with respect to how do you think about an individual case, but because so much antitrust doctrine depends upon a crude empirical judgment about the relative costs of false positives and false negatives. And that current prevailing judgment, which I think probably dates back to, or at least its popularizer was Easterbrook's 1984 article, that crude empirical judgment says, well, markets correct pretty well. If that's wrong, then we may want to reconsider a whole lot of antitrust doctrine. So that's just point one. Point two, the Microsoft case was about conduct whose only apparent harm was that it raised entry barriers to a market which was already surrounded by substantial but not insurmountable entry barriers. And that strikes me as a really important reason to bring a case if the facts support it, because entry barriers really are important.
I guess just briefly, I guess on tech platforms, for example, in particular, I think one of the things that's challenging about issues like entry in the tech space is it's so important or so easy, or however you want to describe it, to differentiate yourself. And so then the question is, who's really competing with whom? Like, exactly how closely do you have to look like somebody else to be a competitor? So, Doug mentioned the Microsoft case. The really impressive part of the DOJ's case there was recognizing that this little browser company that didn't amount to anything was in some ways either a current or potential horizontal threat to an operating system competitor when it had no operating system, nor was it ever going to have one. And I think that so the fact that a little company like Netscape could enter and threaten sufficiently existentially a company as established as Microsoft in a way to engender the kind of response it got, tells you something that important about, I don't know if you'd say, does that make entry easy or hard? I do think it makes it a challenge for antitrust agencies to recognize competition. So when sometimes people have criticized various mergers, they've been talking about companies that didn't look, at least on one side of the market, like they were competing very directly. So how could a company like Instagram with 11 employees ostensibly be competing with Facebook when in fact it had a highly differentiated product? So I think one of the concerns or issues that the antitrust agencies need to be dealing with is, I think, what made Microsoft so powerful, and it was heavily influenced, in my view, by Borg's analysis, was that it was a horizontal competition. It wasn't trying to argue about leveraging, but you have to be creative in recognizing when something is in fact a horizontal threat.
But just to elaborate, I mean, are the barriers to entry in the broadband and the telecom space not much hugely greater than the barriers to entry in a platform space? I mean, when net neutrality came down the line, the tech companies were pushing for strong rules to regulate the supposed monopolistic broadband providers, and then the answer comes back, well, what about the power you have? They say, well, competition is always a click away. So I'm just wondering, does that kind of logic in the public sphere impact this discussion we're having today about platform economics and competition?
Well, look, I think it's in the big sense, it's a very dynamic economy. And if you go back and look at the arguments in the 90s, I thought the Microsoft case as it came out was a good case, but some of the arguments that animated it were this extreme version of network effects, and we were going to have lock-in, and which is a crazy argument, particularly in retrospect, but even at the time, given that the way things were changing. And if you look at all the change that's occurred, I just wrote something that I put on SSRN for the first day of the FTC's hearings. It's called, "Will the FTC's success continue?" And the FTC's model is under assault by the populists and under assault by the paternalists, the CFPB model on the consumer protection side and the populist on the antitrust side. And if you look at these tech companies that have arisen, and these tech companies are all different. I mean, some of them, Google in particular, have very large market shares, which is a prerequisite at least to worry about them, where others don't have large market shares. But you look at them collectively, they could not have arisen anyplace else in the world except for the United States with the kind of antitrust laws that we have. It's how I ended this paper by saying that you look at if the rules that the populists want had been in effect, around 2000, their lawyers would have been telling them, you've got to pull your punches. And fortunately, those rules didn't exist. But you've got these people who, I've got in front of me some speeches by Mike Perchuk, a guy most of you probably never heard of, who is Barry Lynn. Same words, same kind of things about how we shouldn't focus just on economics. He was chairman of the FTC starting in 1977. He came to a bad end. I don't know if President Harris's FTC chair will come to such a bad end in a few years. But I wonder in this paper whether the FTC is going to find itself in a Groundhog Day where it wakes up each morning to 1975. But that's the populist dream.
I can't resist, if I can, just another brief comment. I completely agree with Tim that we shouldn't be abandoning what I referred to earlier as Bork's normative propositions about focusing single-mindedly on economic welfare and so forth. But I think we can't be too facile about saying, well, there's been innovation in the past and therefore we don't have to worry about the future. I'm not sure how far my concern goes, but just want to tell one little anecdote. So when I was in the Justice Department in the Microsoft days, Microsoft comes in and their economist puts up a bar graph. Their point was, don't worry about this, we're competing for the market, it'll be leapfrog, we're just a temporary guy. And they put up a bar graph in which they had time across the horizontal axis. And they would take various functions, like spreadsheets, and they started with VisiCalc, and they had a bar for how long it was dominant. And then it was Lotus 1, 2, 3, and then it was Excel. And did that with 3 or 4 functions. And I remember looking at that and actually asking their economist, saying, doesn't that actually prove the opposite? Because each of those bars got successively longer. Now, my intuition then, and I gather there's been some economic work suggesting I wasn't entirely insane since then, is that it had to do with penetration. That if 10% of the people are using VisiCalc, it's not really very hard for Lotus to come out with a better product and get people to use it. But if 90% of the people are using Excel, leave aside linkages with Microsoft, it might be very hard to get people to change because of transferability of files and learning and all that. So all a way of saying, I agree with everything Tim said, except we got to be a little bit cautious about the extent to which past is prologue.
Yeah, while I agree with that, Doug, I do think it's interesting that, Catherine Tucker, for example, had an article, David Evans had an article called about sort of platforms, I think Sleepless Nights was somewhere in the title, that, whenever people talk about like big data or something, Dan Rubenfeld has an article on this where he kind of categorizes it in 4 areas. What you see is that as each potential barrier to entry goes from physical to virtual, barriers to entry actually are going down. It gets easier and easier, whether you're talking about storage, analysis. We're now to the point where with the cloud, you're actually being able to download entire sort of commoditized chunks of code, and so the ability to kind of to pull together a software program, even a complicated one, is getting cheaper and cheaper. It's virtually costless to store and analyze data. So I just, while I agree with Doug, that obviously you can't just sort of extrapolate kind of from and say past as prologue. All of the things I'm aware of, that sort of when you talk about like legacy data, when the FTC gives examples of, sort of mergers where there may have been big data, those all turn out to be historical legacy data examples. So, sort of photos of rooftops from, before the hurricane went through. Well, that's valuable because it's not online and isn't digitized. I was involved in a Westlaw Lexis case back in the 90s, and everybody said, yes, well, sort of on the internet now you'll be able to get old cases, but there's literally nobody has state court cases in important states from the 1950s. That data is really hard to replicate and really valuable. So I'd like to see the case, my intuition, and sort of, I think there's reason to believe that barriers are actually tending to come down, not up.
Let me try to turn this back to the subject of the panel a little bit. There are a number of things we said, but this one just sort of came to mind on the net neutrality thing which you had raised. People don't like single monopoly profit. Okay, fine.
but it's a useful guide because it forces one to ask the question, well, let me put it this way. There are a lot of people who believed that broadband companies could willy-nilly offer less valuable service, inferior service to customers, non-neutral content delivery, without paying a price for that. That was essentially a free bad act that they could do for whatever nefarious reason. There was no benefit. You have to look at that. And one would, let me just say without going into detail, because I probably can't go into detail, and one might ask, why do you think that? Where is that coming from? What's the argument? And whatever sort of variable portions, sort of stories one can tell about those kind of things, I think Bork is still useful, and it forces people it leads people to ask, and I think forces people to answer good questions. And sometimes they still don't answer them.
You had things to say about congressional intent, but before we go there, I want to ask another hypothetical, a counterfactual question. So if we believe that antitrust paradox did mark, or at least was crucial in a change in antitrust, what would the economy look like today if it hadn't happened, if there weren't that trend? I mean, we heard earlier, I guess it was John Nectarline talking about saying how rather than, we had conglomerates earlier on. So it's not as if we would have more small businesses now instead. But what might the economy, what might firms look like today if antitrust hadn't changed?
Well, maybe I'll start with that one. So I did want to pick up on a point that I completely agree with Tim on, that he made early about, kind of, we do have a little bit of a natural experiment of what kind of innovation did we get in the 50s and 60s. If none of you have watched it, I'd commend a TV show called Life on Mars to you. It's about somebody who time jumps back from 2008 into 1973, and it's like going to Mars, because it's just sort of the complete lack of any dynamism in the economy, and just, it wasn't all that old in 1973, but I mean they put a lot of effort into getting 1973 right. And by comparison, sort of around the same time as Bork's book, the first real cases dealing with, sort of when does vertical integration in tech amount to something anti-competitive were the IBM peripherals cases. I think those were in the late 70s. And the question was, is it a bad thing for IBM to be integrating, sort of sort of no longer have separate storage and stick it into one thing? And so instead of having a whole bunch of, you actually have a laptop there instead of having a bunch of cables and peripherals that you brought with you. One of the things I think Bork's emphasis on looking at the benefits of vertical integration made a huge difference in terms of how the tech industry evolved. Because having spent most of my time in and around the tech industry in my career, that is the rule rather than the exception for the way that tech innovates, is through vertical integration. And so if that is presumptively illegal, then I think you end up with a lot of peripherals as you're lugging around, and we've seen nothing like the tech revolution that we've seen here.
It's possible that we have another more current natural experiment in terms of innovative markets, and that's comparing the United States and Europe. Europe's had a more interventionist competition policy, and it's possible that is partly explains the fact that the big companies that they keep coming after tend to be Americans, the innovative companies.
At least early on, though, after the book publication, for the next 10 years at least, Europe seemed to be okay with vertical integration as long as it was part of their formerly state-owned enterprises, right? They tried to privatize them as big, vertically integrated pieces, right? And we were breaking up AT&T. I guess that changed.
Over my depth now.
Yeah. Tim, you wanted to talk about, oh, sorry, I'm so abrupt, but talking about congressional intent.
Oh, well, this has to do with the total welfare versus consumer welfare debate, as opposed to the debates we've had earlier today from Doug and others about consumer welfare versus a whole bunch of other stuff. And to the extent that I share Doug's view on that, about the problems of dealing with all that other stuff. The only thing, but one of the things is that I think when it works through your papers, it's probably also in the book, and sort of engendered this debate about total welfare, despite him calling it consumer welfare, and consumer welfare by people who don't want to treat efficiencies or take those into account or take them account in sort of limited ways. Leaving aside issues about how much congressional intent matters in litigation, which I am not an expert, I have always found that debate uninteresting, and will be curious if anyone else feels this way. Not so much because of the merits of one side or the other, but just how nobody in that debate on either side seems to argue against interest. It's that whatever I think antitrust policy should be must have been what Congress intended it to be 100 years ago. And somehow, if that's the nature of the argument on both sides of the story, this is not an interesting issue. I'm learning nothing from this, other than what you happen to already think is what antitrust ought to be like.
So what's the takeaway from that?
The takeaway from that is I wouldn't bother with it. I mean, I just told you what I thought of it.
Oh, okay, okay.
I mean, it's gotten, and continues to get a lot of attention in a lot of circles, and it's just not something that has ever done anything for me. But maybe others feel differently. And it is a big part of the work versus others legacy.
Yeah.
But maybe this is not just one part of the Bork legacy we haven't really talked about directly. Maybe is sort of error costs. So one of the things that we don't tend to understand, for example, about platforms and vertical integration is like, why do they do it? Right. So Doug was at Intel for a while. There was an interesting study about why did Intel, and we always tend to think of platforms as digital, but almost every tech company, honestly, is a platform one way or another. So Intel is a platform. Why did they sometimes choose to vertically integrate into complementary space? And it was really an interesting. It was an empirical study, and it suggested that it was when the complementers that to be on the Intel platform required a lot of platform-specific investment, and Intel would tend to vertically integrate where the complementers weren't doing a good job. And so it was effectively to kind of spur further competition by the complementers. Now, by comparison, there was an article last year about mobile apps and why do Apple and Google sometimes innovate forward into particular mobile apps, completely different space. There being on an app is characterized by having just sort of free entry effectively, and I think the economists would tell us where entry is free, you tend to get too much of something. And so it was an interesting paper, I thought, empirically was looked at, there were something like 30 times that Apple had innovated. I think one example was into flashlight apps. Why did Apple decide to create its own flashlight app, and then Google promptly responded with its own flashlight app? That happened about 30 times that they studied. One thing was interesting was about 80% of the time Google copied Apple. Sort of if Apple did it, then Google did it. Their studies suggested that there was an important effect in pushing away innovation from what had effectively become overproduction of commoditized. We don't need any more standardized flashlight apps. It reduced innovation. What it did is it created more differentiated innovation. So it benefited both platforms. So it was actually turned out to be a species of inter-platform competition. So an important part of what Bork taught us is we don't, so let's be modest about what we know. I think economics and empirical studies show us interesting things that we don't always understand about, like why do platforms sort of vertically integrate? Those are two very different reasons. Maybe there's a third reason that would be anti-competitive. But I think Bork taught us, and we've been living in a world, at least in the United States, where we tend to look before we leap.
That's a pretty good summary of one of the legacies. Maybe that's a good way to sum up. Does anybody have something to say about what they think is the most important, the most important aspect of the legacy of the book or his broader work?
Nothing to add what I said.
Okay. Well, I should give you a quick chance. If we could take one more question, if we wanted. Yeah. Okay. Hold on.
Thank you. My name is Nicolas Petit. I'm a professor in Europe. So I have a question about one class of risks that seems to me to get sort of not really analyzed in antitrust. So when you read about probability theory, people talk about two types of events. You have, fat tail events, which basically represent likelihoods of harms which are very low, but the harm may be very large, and I wonder to what extent we've done enough in antitrust today to deal with those situations. So in the discussion on, whether large tech platforms absorb small startups, and one day the startups could become the next Google, the next Facebook, and so on and so forth, whether we've paid enough attention to the possibility that there's not just one type of harm. There's low likelihood, large harm types of transactions, and there's high likelihood, moderate harm types of antitrust damage. And there is some work being done in other fields of science on those types of tail risks. It's typically the type of risk that you have when you think about climate change, for instance, right? And I wonder whether related to what people on the panel were saying before, we should actually try to move beyond our collective lack of knowledge and embrace this more sophisticated ideas about how to classify distinct types of harm. In Europe, I think the perspective of enforcers is that in situations of uncertainty, the default would be enforce the law, whereas in the United States, in situations of economic and technological uncertainty, the default would be do not enforce the law. And I wonder whether we can refine our analysis, thinking, more precisely in terms of the types of harm we're talking about. And if you have any views about that, that'd be fantastic.
If I understood the question, I think it actually touches upon a really profound question in law, which you might think of this way. If you're doing a damage case, I've destroyed your business or destroyed your house or whatever, and you want to ask, well, what would it have been worth in the but-for world? Are you trying to do a point estimate, in effect the mode of the distribution of possible paths that business or that house would have taken in the but-for world? Or are you trying to describe the whole curve? And maybe determine, I don't know, the mean or the discounted present value or something like that. And the truth is, I think the U.S. law is very uncertain about which way it wants to go in that direction. But it seems to me what you're saying is in antitrust is, what if we have a situation where, Facebook buying Instagram, let's say we knew at the time that in all probability it was either of no consequence or would reinvigorate an entrant that wasn't going anywhere anyhow, but that there was a tiny chance that it would wind up owning what would have been the biggest threat to its market position. Should there be some decision algorithm, whether it's they're looking at the mean rather than the median or whatever it is, to say, well, in some of those cases, maybe we want to prohibit the merger. And I have no answer to that question, but I just wanted to try to frame it, what you were saying, if I understood it correctly, a slightly different way.
It's a bit like, the VC world thinks a bit about like that, right? They take tons of positions in many, companies, and the likelihood of one of them thriving is very low, but when it hits, it's like a 1 billion, profit opportunity. And so I wonder whether antitrust enforcers should think more like, VC people when they think about harm and efficiencies.
But the problem is, VCs get away with it because they have portfolios, so they can make decisions under great uncertainty. Antitrust enforcers, I don't think, should be looking at their cases' portfolios. So they have to, it seems to me, they have to have a higher degree of confidence that they know what that tail looks like than simply, well, it could be, let's just block it.
Yeah, this is a little bit random, but so, you know, if you just, when you mentioned the VCs, and, you know, so if Apple has entered 30 markets in this, study was over the course of about 4 years, it's probably entered a whole lot more since then. Are we going to sort of eliminate, you know, sort of 30 pro-competitive interventions in the hopes that somebody might say, well, that flashlight app might actually have turned out to be the thing that was going to create the next great platform. You know, pejoratively, somebody could say, well, so Apple was creating a kill zone in flashlight apps. You know, sort of it's pushing people away to have to innovate. You know, Doug mentioned about kind of comparing the US and Europe. You could kind of view China as a command and control natural experiment that they actually chose to emulate the United States, not Europe, when they're setting up their, they're ordering their tech companies to look like something. And what they do is they have a lot of big tech companies that people tend to forget about. They'll look exactly like American big tech companies. And you know what? They order their big tech companies to acquire lots of little tech companies as a way to spur innovation. So, you know, I have a friend who's a VC in Sequoia Capital, the grandfather of all the VC firms. He told me this is the first year in which Sequoia Capital is investing more money in China than in the United States. So I think if you sort of follow the money, it would suggest that a powerful way of creating innovation is you actually let the market work, even in a command and control economy.
All right, well, with that, let's thank the panelists.